Can we have
No
it
private
tomorrow?
respondents, my lord. All of them are present here.
Mr. Rao, get instructions, right?
Lordship, kind permissions, Millard. Matter pertains to transfer of teachers, your lordship. Millard, in WP number.
What do you want, madam?
Millard, I
Final hearing.
complete petitions and vacate petitions, Millard, without making me as a party, Millard, who is the recognized association, Millard. Petitioner filed the writ petition, Millard, and obtained interim order, your lordship.
9th August, 9th October, 9th October.
Millard, tomorrow in
Then what?
Millard, counseling for teachers transfers is going on, your lordship.
Nothing like counseling for admission to PG course is going on. What counseling, madam? Transfer is an incident of service. Nothing is being done. You are not being hanged. If you are unable to post, you get yourself posted in Hyderabad, that doesn't mean that end of the world, right? We will decide it. Vacating stay you have filed, no? 9th October. Or we 5th October. 5th October.
Much obliged, lordship. 2:30, lordship.
Vacating stay petition, madam, it will be listed in motion hearing. Whenever it comes, if you are not present, we will adjourn it.
Much obliged, lordship.
This is not for final hearing, right? Yes. Next.
That I filed included vacation petition cases where Millard's tongue to granted stay of allegation on the ground Millard's granted to President Lord.
Which case?
Millard,
Vacate petition, which case? One at a time. One. One.
That two implemented vacate, two are connected. One is social welfare society, tribunal.
5th
Only one
October.
man.
5th October.
Much.
Yes.
Madam, your lordship, sir.
Yes.
Item 23 to 25.
Item.
Right.
Yes.
Last items called.
No, we thought that you are appearing in that very case of Mr. Prabhakar.
Not the list items would be called.
Lordships,
Yes.
In the list, I thought we had called.
It will be called. Yes.
Lordships, in this matter, 76 days delay is there that Millard, without making me party, has been allowed the repetition learned single judge, which is erroneous.
So
Millard.
what is your remedy?
Remedy is there that Millard,
63 Supreme Court.
Lordships,
63 Supreme Court. Have you read it? Everything.
Sir, already notice has been served. You have given explanation. What survey?
But,
All participants.
But without hearing me has been,
What we will,
allowed the
the
petition.
district
Milord,
collector will hear
it
you.
is Lorships.
There's no, this court has not granted title. District collector will hear you. We will direct that. District collector, before passing an order on the application of the petitioner, will hear you.
Yes, that is enough to me.
That's what. Yes. Heard on so and so IA 1 of 23, permission to the reasons assigned permitted to file an appeal, then 2 of 23 reasons assigned delay condoned.
May I please your lords? Lord, the
No.
those originally, Lord, under Protected Tenancy Act, Lord, a certificate of ownership was issued under section 38E in the year 1975. And the certificate holders' names were mutated from the year 1995 in the revenue records. Subsequently, they sold the entire property to various third parties, and ultimately the appellants before your lordships are.
Where is the ownership certificate dated 24/7/75?
Lord, it is at page 267.
267.
So 270, Virat. Fair copy.
2
Fair copy 270.
270.
Certificate of ownership under section 38E of AP Telangana Area Tenancy and Agriculture Act. Second para 4, Milord Kalopolu Chandraya. If your lordships can please turn the page, Milord, survey number 89, 11 acres. Milord, what happened, Milord? When these people, they have filed a revision directly bypassing the appellate remedy under section 55. After 20 years from the date of changing the entries in the name of the PTs, without arraying the parties, all the present owners as the parties, we got ourselves impleted, Milord. The question arose.
Who appears for revenue department? What is your stand? You will have to take a stand, right? Whether this, when there is this thing, finding that by learned single judge that this such a ownership certificate does not exist. What is your stand?
No counter has been filed before.
No counter filed, Milord. No record.
No counter has been filed and no.
At least you produce the record.
Yes.
This intra-court appeal has been filed against an order dated 10/7/2023 passed by the learned single judge, by which a writ petition preferred
Item 5 also goes along with this.
Acha, 5 also same
Again, it's
order.
the same judgment of learner single.
All right, same order.
But my lord, I am appearing in 5. My lord, I am instructed to appear in 5.
Ah,
My lord, what we are asking is, my lord, suspension of the judgment so that their entries are directed to be, my lord,
let
entered.
it be entry be made, what doesn't make any difference.
So
We
far
have,
it is- so far it is
we
not-
will hear you then. We will hear.
My lord, may I-
Let it be called. Let it be called. Yes.
Yes,
Item 3.
at least lordships.
Ah, Mr. Yes, Mr. Rao.
But the appeal is filed against an order
Ah,
passed by the learned single judge directing college in which, my lord, the reputation was admitted in BED course
ah.
to return the original certificates to enable him in admission. That the learned judge did not observe about the rule. Rule mandates, my lord, that the candidate who discontinued the course has to pay, my lord, 20 lakhs rupees as a penalty. But when we insisted, my lord, the petitioner filed a contempt case.
All right, heard on the question of admission. Huh? Issue notice on behalf of one.
May it please your lordships.
Ah,
My lord, this writ appeal is filed before my lord against the order of the learner single judge dismissing the writ petition preferred by the appellant, whereunder my lord we have sought for issuance of a writ of prohibition to declare my lord the proceedings that are going on before the learned first senior civil judge deciding the issue whether the property is a work property or not has to be decided only my lord by a work tribunal. But the learner single judge was pleased to.
no, but that's correct.
Yes, my lord.
But who are you? That's the
Well,
question.
I'm a person interested and I'm already instituted a suit for declaration of the entire property as a work property.
That
My lord.
the learned single judge recorded a finding that you don't have a locus, as you don't claim any distinct interest
Yes,
in
but-
the work property.
Yes,
How
but-
are you?
The learned single judge was pleased to observe that as I'm not a party to the land acquisition proceedings,
Ah.
hence I have no right. In fact, I am a person interested in falling within the definition of section 3K of the Work Act. I'm a person interested in protecting the work property.
3K work fact, madam. What does it beneficiary?
Yes, my lord. I'm a person, I'm a musalli and I'm a regular congregant of the mosque attached to the property. As such, any my lord, effect to the property would certainly affect my rights. And I've also mentioned in my affidavit, my lord, but I'm a person interested in protecting the work properties. I'm a social worker also. I have no personal interest involved in this property. What I'm seeking, my lord, is that the property, the list should be decided by an appeal court as per the Supreme Court dictum, my lord.
What is being decided before the civil court? LAOP means what? LAOP?
LAOP is the proceedings where the collector has
Compensation.
Yes. Settlement and determination of compensation to be paid to the right person.
Ah,
There is a private party.
that question will be decided if there is a dispute with regard to identity of the persons to whom it is payable.
Yes.
According to you,
Yes.
it should be paid by, it should be payable to the work, right?
Work,
Because
yes.
it's a work property.
Yes. The
Then
records,
that power is there, no?
the records show that it's a work property. Notices were issued to.
This is under Land Acquisition Act.
Yes,
or
ma'am.
1894.
Yes, Lord. Old 1894.
1894. And there is a provision, right? Where if
Section
the-
30. Section 30.
That the dispute you also file, if you are entitled to get, you will also get. Go there, file. See, he is not deciding this thing.
Ultimately, the first senior civil judge will have to give a finding whether the compensation has to be paid to a private party or the
Ah, this,
So ultimately, my lord, the learned first senior civil judge, my lord, is deciding whether the property is a work property or not.
yes. Section 30,
Yes.
apportionment.
Yes.
Persons to whom or any part
Yes.
collective decision, it will be decided. This is not under work fact. This proceeding is not under work fact. You file a suit for declaration.
I have already.
Yeah, file a suit against the person seeking, who is seeking compensation to restrain him from receiving the amount. That all is understandable.
May I
But
see
you
your-
cannot say that, see, Mr. The principle of law is,
Yes.
we think that you are open to reasoning. That's why we are telling you.
Yes.
The principle of law is that when the statute creates a right,
Yes.
and consequently provides a forum or creates a liability or a right and provides a forum for redressal of that grievance.
Yes.
That forum alone would have jurisdiction in law to deal with. See, this is squarely so like Work Act, you will this thing render section 30 of the Land Acquisition Act use because it will not apply. Supposing if work property is acquired, section 30 will be impliedly repealed. It will not apply according to you.
Yes.
Huh?
Lord,
Do you understand? Right?
I
What is-
understand, my lord. But now when we,
Then you, if you think you have a personal grounds against the person that he should not receive the
Yes.
compensation,
Yes.
file a suit against him.
Lord,
File a suit, restrain him from receiving the amount of compensation that can be done. But this proceeding cannot be prevented.
my lord, may I say this?
It's very clear. Dispute as to opponent, such dispute to the decision. Yes.
May I say this, my lord? Now there is likelihood of a contradicting judgment that will be passed by two courts. My lord, once one court is deciding the apportionment, my lord, it has to give a finding whether it's a property work or not. Another court, my lord, is deciding the declaration title. Again,
That finding will not bind you because you are not a party to the proceeding under section 30. There is no finding operates inter se between the parties, Mr.
my lord, I am on
You
the
know.
issue. I am on the issue.
No, no.
that the senior citizens cannot give any finding on the nature of property.
That we are
It's
rejecting.
excluded.
That,
Unless
that we are rejecting.
85 of the Work
That
Act.
we are rejecting on the principle. That we will pass an order. We have understood your point.
My lords,
But that's not the case.
the latest Supreme Court judgment which says, my lord, the words used
Question of title, the question whether or not is a work property has to be decided by a work tribunal.
Any dispute includes, my lord, dispute of any nature, be it an application under section 30 or any other application. So it is a wide connotation. That is what has been observed by the Honorable Supreme Court. My lord,
Which judge?
I am referring to, my lord, the judgment of 2022.
No, in the context of section 30, there you see, Mr.
Context of 30.
What you are trying to tell us is it's a this thing. If you want time to study, you take time. But the section, what you are trying to say that section 30 will not apply to a work property, and in case there is a dispute as to whom the amount is payable,
No, I am not-
section 30 will not apply.
No.
That argument we are not prepared to accept.
I'm not pending.
That's what it is.
I said section 30 is applicable.
This is
but
under
Supreme Court
Mr.
not applicable.
Works this thing. What happens to section then? What happens to section 30? If everything, the legislature would have said so. In case legislature wanted, it would have said so that provided in case of work property dispute shall be referred to.
But this issue has come
You
up.
you cannot render a statutory provision nullity because you have a grounds against a person that he should not receive compensation.
Unless there is an
We file a
express bar. Lord, unless there is an express bar.
Which judgment?
Lord, that is what I am referring to, Lord, the
please.
judgment of the Honorable Supreme Court, which has distinguished the earlier Supreme Court judgment and said that
Section 30.
No,
30.
Section 30 has fallen for consideration for the first time, my lord. If I am subject to correction, I have gone through all the judgments.
Yes.
Section 30 has fallen. My point is like this, limited
Yes.
point. Section 30 empowers collector to refer it to civil court. Tribunal is also a civil
And-
court for what purposes?
So this civil court means tribunal. This is what you want us to read tribunal instead of civil court in case of work property. This is something right interesting, but you will have to show us the case law.
Lord, I'll come back.
Your Lordship, section 83 of 5 says that Your Lordship of perfect of
Where is
tribunal is this civil court. Deemed to be civil court, Your Lordship. Section 83 5.
Fine. So
Subsection 5 of 83. That is correct. This should be referred to the tribunal only, Your Lordship. Because it is said that section 30 says the decision of the court.
no, you tell us any case law to support like saying this. It should be referred to Supreme Court. Also, you can say.
The Supreme Court
like-
says that any dispute, Your Lordship,
Listen,
any dispute, it is
you can-
apportionment also in dispute, Your Lordship.
Any decision to support your proposition that it should be referred to.
The
work property.
amendment is latest made, Your Lordship, in 2013, it was made the amendment to the any person and any.
No, I mean, this is the way of arguing, like just saying something and forgetting about it, then we are not this thing. We are passing an order right away. Just like, if you want to examine this point, it is like saying that it should be referred to. Why? Because you think it should be referred to work tribunal.
No,
That-
because it is.
What is, we are asking you any precedent on this. What is the legal principle to support just making a statement, I want it to be referred to work tribunal?
No,
This is how we decide a legal issue.
No.
Because you want. This is not possible, Mr.
I bring it to the lordship's notice, my lord, the latest judgment.
Just one para.
My lord, paragraph number 62 onwards, my lord.
Mr. Citation
my lord,
first,
yes,
at least, I mean,
the judgment is not 2022, volume 4, SCC 414.
2022 4 SCC.
414.
On what issue?
The issue is with regard to the jurisdiction of the work tribunal. What are the cases which can be required?
Jurisdiction of work tribunal, it has the power to decide whether a property is work property or not. Who is saying?
Earlier Honorable Supreme
This
Court
is-
said, my lord, earlier Honorable Supreme Court said that, my lord, the eviction suits are precluded from the jurisdiction of the work tribunal. It says any other dispute may come within the definition of the jurisdiction of the
No,
tribunal.
Mr. See, if you want to argue like this, we will decide it right away.
But I'll
If
come
you
back.
want time,
Yeah, I'll take it.
better be prepared.
Yes.
You understand what is the query.
I understand.
Don't be like him that it should be sent to work tribunal. Because he feels it should be sent to work tribunal. This is not we can decide it. It requires a deliberation.
I will come back.
You better prepare it and you are capable of doing it. That's why we are telling you. You better make a research on this.
I will come back.
That how can, what circumstances the provisions of an act can be, like what is the interrelation, how the Land Acquisition Act and Work Act are interrelated. Whether, I mean, the Land Acquisition Act are subservient to provisions of Work Act. We don't know. I mean, this is what you should examine.
I understand.
What
the
will be,
special enactments, my lord, I will just.
which one will prevail?
Yes.
Whether the express provisions can be read into construed in the case of by interpretative process.
I will.
If so, what is the rule of interpretation which would apply? Just saying that it should be referred to work tribunal will not help.
I will
Right?
text it.
This, if you have to then make out a point.
Yes.
Prima facie it appears to be difficult. Make out, you may get something. We are not saying. Learned counsel for the petitioner after yes.
Make lordships. My lord, as in the case of item number 2, my lord, this also, my lord, appeal arises out of the same judgment. My lord, just what I was trying to bring it to your lordship's notice is, my lord, the direction of should be the learned single judge is to alter the, my lord, entries in the revenue.
Nothing happens. All the revenue entries do not confer title. It
No,
will
true,
be
Malad.
subject to result of this writ appeal.
True, Malad.
The only apprehension is that it should be, it can be sold. So we have put a rider.
May only, subject to your lordship's pleasure, my lord, may only bring to your lordship's notice. So far, entries have not been corrected in pursuance of the judgment of the learned single judge. Now that your lordships are asking the government to produce the record, that will be clinching, my lord, 75, my lord, whether the satiety certificate has been given or not to our predecessors in title. But I am a fourth person in the line, my lord, who has purchased it. We could not produce the certificate because I am not directly purchased from the original owner. But entire 11 acres has been, my lord, purchased by each individual 1 or 2 acres. My lord, entire property has been sold by the persons who got the certificate. So, my lord, my friend has also shown the certificate to your lordships. In fact, we do not have the copy. But my only request is, my lord, if your lordship say entries, my lord, which are there from 2006, entries are there in our name, my lord, from 2006.
What do they confer title on you?
No, absolutely not. By any case, when it is not changed, my lord, your lordships can also pass an order, my lord, by submission to your lordships, but subject to what your lordships say. Saying that let the entries be not changed, my lord, until the date of hearing.
Earlier case we have restrained them from telling it. That's it. Yes, heard on the question. Same order, item number 2. Then say needless to state that any change been made in the revenue record shall be subject to outcome of this appeal. Any change if made. Same order. Yes. Yes. Item 6. In terms of the grades, and they in the atrocity on the. Yes. Who will tell us?
Made lordships.
Yes, yes. We are issuing notice.
Let's.
We are issuing notice, not on the question of admission. Issue notice.
Extreme prayer is Malad to consider my representation which has been given on 9th January, Malad, which is in detail. With your lordship's permission, Malad, may I hand over the report which has been, Malad, page P16. Along with that, Malad, we had to give the report. Malad, the report is bulky, that's how the registry, Malad, has not taken it. But if your lordships look at the report along with my representation, Malad, on 9/1/2023, I've given a detailed report which has been marked as Exhibit P16.
What interim a representation they will reject whatever, and then you will again amend the petition. What? Let them respond.
Fine, that I leave.
Right. We'll keep it open. Right. We're
Yes.
not passing any order.
May
Issue notice.
we may be permitted to give the report, Malad, to be kept.
Yes.
Malad,
What report? Whose report?
no, Malad, this is Malad independently, Malad, the petitioner, Malad, has made the inquiries with regard to the people, those who have been given registration and those who are running without
A
registration.
report prepared by, yes, madam. Report prepared by the
Obliged.
yes. Password. Notice.
Very brief, though. Seeking direction to the respondent for to fight. To allow me to commence the contract work period which was entered on 15/2023.
Third on the question of admission notice. Admit notice. Notice you say, don't admit. Notice returnable 4 weeks. Respond, yes. Memo has been filed. A memo.
The so you're appearing for respondent. Appearing for respondent, both are writ appeal.
The writ appeal has become infractuous.
Oh, learned counsel for the appellant. Writ appeal.
Writ appeal has become infractuous.
Learned counsel for the appellant, item number 11. This intra-court appeal has been filed so and so.
In fact,
Learned counsel for the appellant submits that
about millet, the filing of the writ appeal and also service of notices. The learned judge said millet, the merely filing an appeal would not operate as a stay, therefore you are being punished. That was millet the order passed. But subsequently in the writ appeal there was a stay granted. Therefore millet the contempt millet appeal may have to be millet disposed of.
When was this stay granted?
Millet stay was granted millet on 16/3/2020 millet.
16/3?
2020 millet.
No, when was the order passed in rate? What is this?
Millet, there was an interim direction on 27/9.
No, what is this about?
Millet, the
Order, this is for willful disobedience of the order dated 27/9/19.
yes, millet, the learned judge directed to millet delete this.
Where is that order? 27/9.
27/9. Millet, at page 1C, millet, I have extracted the order.
This 22A, denotifying.
Yes,
So against this order, you filed this thing,
yes, ma'am.
a writ appeal. 16/3/20, the writ stay was granted.
Stay was granted.
So this is for a period from about 6 months.
Yes, ma'am.
Why did you
And
not?
on the date of millet taking of the contempt case, millet, there was no stay granted, only notice was ordered. Therefore, the learned judge said that it would not operate as a stay mere pendency of the writ appeal. Therefore, you are being punished.
When was this order passed by learned single judge?
Millet, on 27/9/2019, millet. It paid
No, that is an interim order. This
yes,
contempt order.
contempt order, millet, is 20th February 2020, millet.
20th February.
2020, millet.
Okay.
Now that millet, the order has been complied with, they were also issued with Patadar passbooks. Therefore, millet, the writ appeal has become infractuous.
As far as writ appeal 126 is concerned, wherein sufficient was made that it has become infructuous. There is one clarification I would like to see. The property is still being shown in the prohibitory list under section
It's their
22A.
appeal. It's their appeal.
Yes, I agree. But then,
You file whatever you want to.
then the contempt appeal would still stand there in that case.
Huh?
The contempt appeal would stand there.
Though what is, like they've been granted stay, right?
Yes,
Even though belatedly.
yes.
So they were prosecuting. When did you file a writ appeal?
Millet, the
You had filed the SLP also.
yes, millet, against the earlier order millet of the division.
When you tell us, Mr. That's all.
Writ appeal millet was taken up for admission on 17.
Against 27/9/2019, you had filed a writ appeal.
We have filed a writ appeal.
When?
27/2/2020, millet.
27 to
2020, millet, with a delay of 100 days.
uh,
And the matter was taken up millet on 24/2/2020 and the notices were ordered.
all right.
Then millet on 16/3/2020, millet, this honorable court was pleased to grant stay, millet. But subsequently,
16/3/20.
yes, millet, 16/3/2020.
Yes. What do you say?
Well, as far as the contempt order is concerned, that is still in force. In fact, in view of the withdrawal of writ appeal 126, then millets we have.
Withdrawal. He says infructuous. Why should he? They are contesting. Why should you say that the writ appeal has become infructuous? They are contesting, right?
Yes, they were issued with passbooks also, millet, who have implemented the order. Because millet, in the earlier
No,
round,
he's still contesting. All right. Yes.
Millet, the dispute is.
No, this is Mr. Contempt.
Yes.
You have to justify that the sentence should be imposed on them and appeal
Yes,
should be
yes.
dismissed.
The only point then, my lords, is that the property is still shown in the record as under section 22A in the prohibitory list. It's not been removed. As far as issuance of Patta passbook is concerned, that's a different issue. When I go to registration in the Dharani portal, the property is shown in the prohibitory list. So therefore,
Yes.
I am not able to register. Now, once it is not removed.
Properties are still shown in the prohibited list.
no, millet, as per my instructions, millet, it is not, millet. Your lordship may kindly grant me a short adjournment. I'll get back, millet, with the details.
My lords, In
Ah.
fact, we have it now, it is still showing as government land and it is also,
No, Milord, that's not correct, Milord.
Show it, show.
it's from the side.
Milord, I'll get it.
This appeal under section
get
19 of the Contempt of Courts Act.
On that only, Milord, I'll get instructions, Milord, with regard to.
No, no, do it within, we are closing the proceeding by granting you a week's time.
I'm obliged.
Very well.
Why instead of proceeding further?
Yes.
There's no point in, yes. Delete. Of course, it's a making a statement that it will be done and not doing it is a contempt. You understand, right?
Yes, yes.
You advise your client accordingly.
I'll.
It's not that we have taken a lenient view. That doesn't mean that he should
No,
sleep.
that advice.
Next round, we will not spare you.
I'll advise.
Yes.
Okay.
Yeah.
Wait, please.
What IA you have filed?
IA 7, my lords. IA 7 is filed,
What is 7?
seeking a direction to the respondents to allot a seat in the subject of her choice
You have
in
filed
accordance with the
I
orders.
filed my counter, my lord.
IA 7.
I filed my counter, my lord.
IA 7.
IA 7 I did.
You don't want to file.
I filed.
Again on invitation.
Huh?
Again on invitation.
What to do?
They don't on themselves ask, my lords, in spite of the fact from day one when your lot came.
My lords, I have just been served with a copy of the IA, my lords, IA number 7. I would like to file a counter.
Well, I'd rather have my guns on the university than on the medical council, because I know what the medical council is going to say after 2 weeks, 4 weeks, 8 weeks. They're going to say we have no role to play. We are done and dusted. Our job is only one of supervision. They are made parties to the IA because they are parties to the writ petition and the writ appeal. Now, just a minute, ma'am. Your
When have you filed this IA 7?
Friday.
29/9.
Then are they not entitled to briefing?
No, my problem is this, ma'am. Tomorrow they close shutters. Tomorrow is the last day for them to deal with all this, and this is not the first time they're dealing with it. This is another nuance of an affidavit and a grievance that I've already raised.
IA 7 we will hear tomorrow.
Tomorrow.
Mr. Prabhakar, write her name and
Millets, Mr. Parsa Ananthanageshwara millets, the government pleader millets appearing for the appellant. It's Mr. Parsa Ananthanageshwara, the government pleader millets appearing for the appellant. He is down with fever millets. Millets may accommodate a day.
Learned counsel for the appellant prays for adjournment. Write his name. Prays for adjournment on the ground that arguing counsel is unwell. List after 1 week.
But there's no application as such for vacating the earlier interim order, but I'm ready with the case. It's a case wherein without impeding us, an order was passed in a writ petition, treating a validation document to be a linked document. But under law, validation is distinct and separate from what is registration. But I prepared a synopsis.
No, it is for admission. We will admit it for hearing. Order of status quo shall continue.
Leave has to be granted. We were not parties to the writ petition.
Leave granted. Reasons assigned so and so IA is allowed.
Obliged.
It's the case, my lord, where they challenge the sale deed registration, my lord. Your lordship,
No,
referring to Satyapal.
Just now senior counsel said, no, you file application for vacation of stay, whatever, we will consider.
Obliged.
Yes, next.
This is the appeal path by the vote. This is the appeal path by the vote against the order of the single judge. There is a delay of 321 days, IA1, and IA2 is suspension for the taking suspension.
Yes. What is wrong with the order?
Wrong is the court below has not considered.
Not court below. Not court below.
Yes, sorry, the single judge. Sorry, sir. The single judge.
Yes.
Has not considered my representation that the.
No, you tell us survey was conducted in the year 1970. And why after 31 years this notification has been issued under 5-2?
To that
31 years.
To that extent,
And it has lapsed under 70 Act, this under 1954 Act.
to
To that extent, certain other writ petitions, writ appeals are pending on the same ground that has been stayed. The single judge which relied the order in
Which writ appeal? The
331.
same order.
Same order.
Learned counsel for the appellant submits that against the common. No, we are not passing any order. We are saying that against common order, he says some other appeals are pending.
Yes.
It is incorrect submission. Incorrect submission.
Submission that exceptions are pending, but that is not told back. Because batch of cases were filed before Sarah told the reader. Disputed the appeal.
Oh.
No. SLP.
Show it to him, not to us.
No.
No, Mr. This is not fair. You are an officer of the court. Don't make factually incorrect submission.
Appeal is pending, my lord.
What appeal? No, you said that writ appeal is pending against the common order. See, Mr. What happens is we should be more cautious.
Yes.
We tend to rely, believing that he is an officer of the court, will not make incorrect statement. But this is what unfair. Is it so?
They preferred an appeal before the Honorable Supreme Court.
No. Which writ appeal was preferred against this order?
1432 of 2016.
Writ appeal.
Writ appeal. Against the order passed by this single judge, that is 33133.
What happened? You tell us.
Batch of cases written.
1 minute. There is no question of batch. This is only two writ petitions have been decided by common order.
Yes.
You are trying to say that this is this is a common writ appeal.
Yes,
One writ appeal. How?
Common writ appeal. 1432 of 2016.
Ask him to read it.
Yes, counsel.
Yes. My lord.
This court in WA 1010 of 2012, similar issue fell for consideration. It was considered and dismissed. No, please see para 17.
Which is, what are you showing?
I published the copy of the Honorable Supreme Court order.
Which case?
Batch of cases, there is writ appeal number 318 of 21, writ appeal number 319 of 21, and writ appeal number 320, writ appeal number 320.
What it has to do with writ appeal with this case?
This repetition was allowed in terms of the disposal of the writ appeal. So against that, the work code has preferred an appeal before the Honorable Supreme Court. Honorable Supreme Court granted only not to create a third party interest, that is the order copy of Lordship before the Lordship placed with kindly looking to that. Here the fact of the case is Lordship. They have included the lands of the individuals in the gazette issued by the court. So that was challenged.
So similar cases order has been passed. This is what you want to say.
The
similar cases.
Yes. Same, similarly set of facts that this Honorable Court land single judge set aside, and against that, they prefer.
Where is the order by division?
I punished. This is the appeal preferred by the work court that is pending. And after that, SLP of
WA 3053. Party shall maintain status quo. Then there is an interim order directing maintaining status quo.
That is not to create any interim order, respond directed not to create third party. Page number.
No. This is Mr. You have given us a copy of WA.
Yes.
I have not given, that is the.
I have given, my lord. I have given 1432 that writ petition is pending. Same facts. Same.
No, this writ appeal is pending, no? You are saying that this writ appeal 3053 is pending.
33133. Yeah, writ appeal 1432 of 2016.
No, you forget about it. Mr. You argue your own case. What is there?
Kindly it may post it tomorrow, my lord. Tomorrow.
Not tomorrow. This is after 3 days it is listed. You argue. I mean, both of you are trying to confuse us by giving numbers and all that without telling what is the point. He has also not told. You are also this thing. Your appeal is listed for orders on admission. Please argue.
Yes.
Forget about it.
Yes. My lord, kindly
Neither
please.
you have told what is the point, nor he has told. He has given us WA 318, 319. That's all. What is it? How is it connected to this? Without this is what the level of assistance is. Unfortunate.
Yeah.
Yes, go ahead.
Yes.
Please argue on admission. We are not concerned.
Okay. Actually,
we don't know because it has not been brought to our notice.
My lord, may kindly please to see. As per.
Read para 17, Mr.
Para 17. No. Para 10, my lord. My lord, para 10.
No.
Para 10 of page 13. Admittedly, the issue raised in this writ petition is squarely covered by the decision of this court in WP number 33133 of 2014 dated 22/9/2016, wherein a similar Gazette notification which was published in the year 2001 based on the survey conducted in the year 1963 under the Repeal Act fell for consideration. This court in this said case has referred the judgment of the Honorable Supreme Court Tamil Nadu Work Board to conclude that the survey conducted under the Repeal Act could not get saved by virtue of Section 112 of the Work Act. Work Act. Para 17, my lord. In similar circumstances, a learned single judge of this court in WP number so and so, referring to the judgment of this court, be authority. Authority is, my lord, notice has not been given, intimation had not been given to the parties who were in possession of the property. But as per para 10, 1954 Act survey was conducted, in 1995 Act was there, Gazette was published. To that extent, writ petition 33133 has been allowed by the single judge. And we have preferred the appeal, that is WA 1432 of 2016.
Name, Mr.
Yes. So
you read para 17.
Para 17. Yes. In similar circumstances, a learned single judge.
We have read it. You have not read it. You read it for yourself. We have read it.
This citation is of 2009 matter. The Work Act has been amended in 1995. Amended in 1995. So, a said judgment, the learned single judge was confirmed by the. Your Honor, my lord may kindly please to see. My lord may kindly please to see. The second citation, Khatija Amal, that has been stayed by the apex court, means it stayed to the operation of this one.
You go to apex court.
No.
We will send you to apex court. Seek stay of our judgment also, Mr. What nobody has been. We have not been told about any intra-court appeal. Nothing, Mr. We are deciding it on merit.
My lord may kindly.
No.
After lunch, it may be posted.
No,
I will satisfy this court after lunch. Kindly.
So why after lunch?
Because I am having.
No, after lunch, so many people have sought lunch motion.
Because I have some other materials to.
No, this is the material. I would tell it, file in before Supreme Court in SLP. This intra-court appeal arises. Mr. After 3 days, the court is reopening and you are still not ready with one case. And there's no justification. Of 2023 for the reasons
May I please? Matter arises under Telangana value added tax.
This has not been considered by any court like previous benches.
It is pending before on. It is pending before the honorable court, my lord. At page 51, I enclose the copy.
'51. What is pending? No.
Amendment is pending. Pending the amendment. Earlier section 30.
No, whether any previous bench of this court has examined the validity of 13(1).
No, matters are pending for consideration of this honorable court, my lord.
Matters. What is this? Is one matter.
This is one matter. Writ petition number 22585 of 2009.
54.
Page 54 order?
Yes. 55, page 55, my lord will get the reference.
In this petition heard on the question, in this
This matter is about the entry tax, my lord. The connected matters are all posted. I mean, they were posted in the month of August. Later, they have not given any date, my lord.
List for analogous hearing along with WP number
7801 of 2018.
80. 18.
18, my
lord. 8.
May I please your lordships? But in the present writ petition, my lord, the constitutional validity of section 95C of the goods and service tax is questioned.
This also not challenged anywhere.
No, my lord. Here,
Admitted. Counter has been filed.
not filed.
Counter.
No, my lord. This is against advance ruling authority's decision, my lord, with the state appeal is filed. Writ petition is filed, my lord.
No, Mr. You don't want to file any counter, right?
No. No, counter is not required.
You don't want to file also.
This is the finding of the advance ruling authority, my lord.
Learned. No, we don't know what. You don't want to file any counter.
No counter is required. Because they are only challenging below the provision of the section 95C. He is not an applicant, he is not intended to maintain such a application below before the advance ruling authority. That is the finding. They did not even go into the merits of the case, Lord.
No, we don't know. We are recording your submissions. Learn.
My lord, I am appearing.
You should be happy about this statement.
Lordship, I am appearing for
You
respondent.
are appearing for whom? All respondent.
No, my lord. I am appealing.
You are a formal respondent. You are taking a ground. It is your order under challenge, right?
Number 4 failed counter. Respondent 4 failed.
Lordship, I am appearing for respondent number 4 in this petition. My lord.
So then,
I am the seller of the property, my lordship, against which the petitioner has filed the petition.
it is for admission. We are asking you whether you want to file counter.
I have
We are
filed.
not asking whether you have purchased or sold or whatever.
No, as respondent number 4, I have filed the counter, my lordship.
Filed, no?
Yes, ma'am.
Mr. This thing. He is a formal party. That's why he is saying. You should say, Mr. Instead of no counter is necessary, you should say, I am the authority whose order is under challenge.
That's what I'm saying.
No, that's what means.
Yes.
You.
Yes, sorry.
You are giving an impression as if you are appearing for all respondents and don't want to file a counter. That's why we told him that he should be happy that respondents do not want to contest. It doesn't matter whether order is set aside or maintained. It doesn't matter to you, right?
Yes.
Uh,
Not 3 minutes for all party.
Heard on the question of admission, petition is admitted for hearing. Yes.
Great.
Next.
Pertains to appointment of chairperson Human Rights Commission.
The petitioner in the matter, my lord.
But I have seen the company statement, based on record, saying that 78 applications have been received. 78 applications have been received, 4 for the person of chairperson.
78.
Applications have been received.
4
for the post of chairperson, 10 applications for the post of members. 4 for the chairperson. 4 applications in respect of chairperson. 10 applications for the
Four application for post.
For the chairperson. 10 applications for the post of member judicial. 64 applications for the post of member non-judicial. The process is underway. You should grant some time.
Now, how much?
4 weeks from now.
Can I just say one thing, my lord? The post is lying vacant since 22/12/2022, my lord, from the past 10 months. And on the earlier occasion also, only after directions were passed by your lordships was an appointment made. In that order also, it is clarified that this cannot be done always.
But this is the
This process ought to have been done before the learned judge had demitted office. 10 months after that, no, next time when they come before your lordships, they are going to say that election code is underway and no appointment can be made. 10 months, there is no human rights commission in the
place this communication before my lords.
What happens? Petitioner's human rights are violated. He has no forum to go. What can we?
Or should I fix some time, but I'm requesting for 4 weeks time. I'll
Then
place this
what
on
4
record.
weeks? What is like, is there a time schedule? What like received application means what?
In August, the applications were received.
1 minute, Mr. 1 minute. This is a public interest litigation.
I'm sorry.
You are not claiming appointment as chairperson of Human Rights Commission.
I'm not, my lord.
The approach has to be different, Mr. Don't like this thing, picking up quarrel on everything.
But 22.
This is, your approach has to be constructive. We have understood, right? We don't need your this thing arguments.
The composition of the committee, section 22, the chief minister is the chairperson, speaker of the assembly is one person, leader of opposition is one. The meeting has to be conducted, should be granted.
So you have to be realistic, Mr. That this is this thing that code of conduct would be this thing thereafter you will say.
May I place this communication on record minutes?
Mr. What is this communication?
The chief secretary's communication to me, to receipt of application.
Mr. Prasad.
This matter, my lord, the affidavit is ready.
Appointment of President of Telangana State Consumer Commission.
State Consumer Commission.
Then
But the affidavit is ready, my lord. We have called for the appointments of district heads, district consumer head. So far as the state commission is concerned, it is now being held by the in-charge member, and now, my lord, we have filed a clarification petition with the Honorable Supreme Court.
no counter we you want to file.
Yes.
So you file it, we'll take it up day after tomorrow.
My lord, I'll file. Day after.
Day after.
Yes.
Learned Mr. Prasad, learned senior, whatever, undertakes to file a counter during the course of the day. List on 5th of October 23.
I'm obliged.
If the respondent has, and respondent 9 has filed his counter on Saturday, we need to file a short reply, no, should have it next week. So I informed
Respond number 9 has filed counter.
Respondent 9 has filed counter.
Learned senior counsel for the applicant submits that respond number 9 has. Yeah.
Madam, that senior counsel, Mr. Vaidyanathan is, he has to advance his arguments on the reply.
Yes. So.
After lunch.
See, we are ready to hear the case. This is the situation, right?
This matter.
All right. This is the result of taking things for granted, right? Let 2:30 it will be taken up. None of the parties are present. All right.
I'm for R5, madam. I'm for R5 and I'm filing the synopsis today, madam. I already made it and I'm filing it now. I'll give a copy of this. Synopsis also, Mr. Mohan Reddy in the last occasion said that we'll file it. We are getting
But
this.
we were asking the synopsis at the time he was arguing that he didn't give. So, right, give it. What?
Yes.
My lord.
Yes.
My lord.
2:30.
I'm sorry.
Whenever, like, I mean, we don't know. Yes. Yes. None for the petitioner, even when the matter is called in second round, it appears that the petitioner is not interested in prosecuting the writ petition. The same is therefore dismissed for want of prosecution. No, everything else except adjournment. Yes. The way you are smiling, we know that you are not ready and you don't have anything, but this is, sit down, please. No adjournment. Sit down. WP 2005. See.
2005, appeal before the first respondent against the interim order, it has been filed. It's no stay against the interim order passed by the first respondent, my lord. In appeal year 2005, it has been filed and there is no stay. Stay has been vacated. But have been influxes also. Appeal of 2005. Stay has been vacated.
Stay has been
Vacated.
What is under challenge?
The impugned order passed.
The appeal has been decided.
For 20 years.
Ah. Yes, in this writ petition, comma, the petitioner has assailed.
No cause survives.
Yeah.
Cause doesn't survive.
Learned counsel for the petitioner sub.
Land acquisition increase in ownership. This declaration has been filed to direct the respondents to withdraw from the land acquisition procedure. The notification was issued under section 4(1) in year 2002, and the award has been passed in year 2003, and the compensation was paid to the petitioners in the year 2004. The land was alleged to have been acquired for the purpose of development.
1 minute, madam. What is it? What have you filed a petition? Why?
Withdraw the land acquisition.
Stand near the mic.
To withdraw the land acquisition notification, Lordship.
Withdraw.
The land acquisition notification, Lordship. Under
No.
section 48 of the old act.
So that power can be exercised when the notification has been passed, the award has been award has been passed, possession has been taken. When
Possession is still with the petitioner's Lordship. It is a vacant site. Though the respondents allege that it has been taken, the petitioners were still in the possession for the past 50 to 60 years, Lordship.
then that is not possible.
In this case, they have invoked the urgency clause, and the petitioners was not given an opportunity to be heard at that point of time. Until today, they have not acquired they have not utilized the land for which they have acquired, and the possession is still with the petitioners, Lordship.
The compensation has already been received. Land Acquisition Act. Land Acquisition Act with commentary.
Lordships may
Commentary.
consider section 101 of the new act contemplates that when any acquired land under this act remains unutilized for a period of 5 years, this has to be returned to the landowners.
Adam,
This
commentary, I said. With commentary. Give that. With commentary. Library, right? We don't have any books here. So you approach them, they can do anything.
let him consider the representation which we have filed earlier. I will make a fresh representation, Lordship, even let them consider and pass orders.
Oh, one day. The counter has been filed by the special deputy collector of India. Position is taken. Here it is. When? When? All right. Date is not given. The release date and civil relate in the civil. Suggestion has been taken, madam, under a Panchanama.
But the petitioner.
Nothing survived.
It is a vacant land, Lordship. The petitioners are still in the possession.
You continue. This is an ideal situation that after getting the compensation, enjoying the money still in possession, this is an ideal situation. Perhaps you should not file a petition. Ideal situation, continue in possession.
The land has not been utilized, Lordship. It has been almost more than 20 years and they have not utilized the land for the
All right.
for which it was acquired.
All right.
Lordship may kindly direct them to consider the representation under section 48, Restrict 101 of the new act, Lordship. If the land has not been utilized for more than 5 years, let them consider and.
This is, madam, 2013 Act does not apply to your case. It does not have a retrospective application, right?
Yes, Lordship.
Section 48, they have said.
Act may be considered.
They have said possession has been taken. We cannot direct release of land under 48. In any case, that does not vest any right in you. You have received the compensation. You have disclosed in your petition.
Yes.
And you are continuing in possession. What can be the best situation than this? This is the ideal situation that you have received compensation, still in possession, utilizing the land. Be happy. Nothing.
It is a vacant land, Lordship.
It will be filed by the project director. Oh, 22.
They have acquired the land invoking the urgency clause under section 17, Lordship. They have been deprived of the right to be heard under section 5 at that point of time.
Yes. Mark the presence, whatever. No, no,
Passover.
no adjournment, madam.
Lordship, seeking for a Passover.
Why? You are here.
Senior counsel is appearing, Lordship. There's a medical emergency, she couldn't come at time.
Huh?
There's a
Medical emergency?
with in
Student?
her place.
Huh?
Senior counsel is appearing in the matter. There's some medical emergency, so she couldn't come now. Passover, Lordship.
Medical emergency?
A personal inconvenience, Your Lordship.
No. Who is senior counsel?
Bhaskar Lakshmi, ma'am, the petitioner.
No, but you are here, right? You should tell us what is the case about. What is the petition about?
So the petition is filed challenging the demand notice of respondent number 3.
Huh.
And
18 years ago, right?
18 years.
18 years ago.
18
That is most important. So demand notice. So what happened? What happened to that demand notice? Was there a stay granted in the petition?
Yes, Your Lordship, there's a stay granted in this matter.
Yeah.
Subject to
Demand notice.
deposit of 3 crores.
3 crores. Oh. So what is the demand notice about?
The demand notice was issued to the petitioner company to pay the
Petitioner council.
petitioner
Why?
company, Your Lordship.
Company.
Petitioner company.
We slightly felt afraid why you should demand notice will be issued to you. Because you are filing petition on behalf of petitioner.
No, the petitioner company.
Then
To pay 30.
what, madam?
The petitioner company entered into an agreement with the government, Your Lordship. For
Demand notice about what? Demand
pay the
notice about purchasing a land in Moon.
demand notice for paying the penal interest, Your Lordship, of 30 crore.
Penal interest on what, madam?
Your Lordship, kindly permit, there's the petitioner company entered into an agreement with the government for supply of hardwood and bamboo. In 1978. And there was a provision for paying royalty on the supply of bamboo and hardwood. In 1981, there was a GO issued by the government. They increased the rates of the royalty on the bamboo. Challenging that writ petition was filed before the Honorable High Court of AP, which was dismissed, and writ appeal was dismissed, and then SLP was filed in Supreme Court, which was also dismissed in 2002. Pursuant to that, demand notice was issued by respondent number 327, asking the petitioner company to pay the difference royalty amount for the tenure of 1980 to 85. Challenging that, this writ petition is filed, Your Lordship.
Pass over, madam. Don't think that it is like gone from the, so you,
No.
if you don't come, we will dismiss it.
No, Your Lordship, bad. Okay.
For the petitioner, my lord, no cause survival.
So you could say this in the beginning itself, right? 10:30. Supposing if the case would not have been called, you would have never told the court, right? Why? Why it is so important, like mentioning out of turn mentioning is important. So this also is important that you could have told us 10:30. Learned counsel for the petitioner submits that the
Your Lordship, Land Senior Counsel is appearing online, my Lordship. I'm assisting him to buy.
What is it?
It's a 2005 matter, Your Lordship.
No, correct.
The public interest litigation, My Lordship, seeking habitations of Chenchu tribes in the forest area to be recognized as revenue villages. Based on the committee report of the government itself.
Company report?
Committee report, sir, there's a committee. May I submit, My Lordship, I may kindly permitted to pass on the report because subsequent developments I want to bring to Your Lordship this. Summary, I made a summary of the dates and Your Lordship, a kind convenience.
What is the relief for?
Relief is, My Lordship, to declare, to recognize the habitations of Chenchu scheduled tribes who are basically vulnerable, particular tribal groups into, My Lordship, as revenue habitations. Now, later a law has come, My Lordship, giving us this as a right. 2006, a law has come. But that law is not yet implemented. I have provided the chronology, Your Lordship. You should learn senior counsel is appearing, Your Lordship.
You are good enough in a public interest litigation.
No,
you have to assist us, right?
He's on the.
There's nothing to argue.
Yes,
they are not contesting.
My lord, I'm there, my lord. That note, your lordship, is placed before lordship. A synopsis note at the dates. So, my lord, in the light of the new 2006 Act, the collector has to pass orders. I grade the last 2 points in that note, second page, my lord.
We had filed my counter affidavit, my lord. Filed my counter affidavit. Initially also their proposals have been examined. The forest department had raised certain objections.
1 minute.
Page 89.
1 minute. Yes.
Lord, the counter affidavit, Lord, along with the counter affidavit, had filed the proceedings of the forest department, Lord. Page 87, stating that the.
No, under this 2006 Act, their rights are recognized, right?
Yes.
And there has to be an adjudication of something like under the Act.
What I'm asking is this writ can be disposed of.
If the pressure
directing
the district collector to pass orders as per the new act, because he is the head of the district level scrutiny committee.
Which provision?
Act in the rules.
Which provision, Mr.
Lord, section 3(1) EH, my lord, of the
Section
2007.
3(1)
EH talks about rights including the community tenures.
Lord, the agents.
Yes, but this Act.
Rules, my lord, 2008 rules as
Scheduled
amended
tribe.
in 2012.
2006 Act. Scheduled tribes and other traditional forest dwellers.
2006 Act. Yes. Act 2 of 2 is called.
Act 2 of 2007.
Yes, madam. Scheduled tribes
Then
and
rules
other.
are there, my lord.
Yes.
Rules of 2008 they were notified. And they were appropriately amended in 2012. That's Rule 7, my lord, is the district level committee.
The same book which is at page number 377, Lord. Yes.
Rule 7 speaks about the district level committee, my lord. Rule 12B, which was introduced in 2012, that's what I'm relying upon. Am I reading Rule 12B, my lord? Process of recognition of community rights. The district level committee, in view of the differential vulnerability of the particularly vulnerable tribal groups, the Chensus are like that, as described in class 6 against the forest, ensure that all particular vulnerable tribes receive habitat rights in consultation with the concerned traditional institutes, so on and so on.
All right. Yes. Let them make a claim
It can be
statement.
passed, man. That's
Let
all.
them make
The
a claim
collector has to
statement.
pass.
Would it be considered?
Huh?
Let them make a claim statement, Manoj, that we'll consider.
They will have to make a claim statement.
No need of a claim statement. It says, so particularly vulnerable tribal groups, 12B, the district level committee shall do it. Because they have already given irrigation pattas there. Lands pattas have been given, but habitation rights have not been given.
You examine, Mr. These people may not be able to. What
Yes.
you will say that they didn't apply? Why?
Yes.
They not contemplate.
Yes.
Right. Mark the presence, whatever. Order. In this writ petition, which has been filed as public interest litigation,
Milord, the present writ appeal is filed, Milord, challenging the order passed by the learned single judge, Milord, dated 5/2/2004 in WP number 16438 of 1997, Milord. Milord, appellant is the corporation, Milord, TS, now present TSRTC, Milord. Milord, the appellant corporation has issued a tender notification on 28/11/1996, Milord, inviting tender notice for allotment of open spaces and will construct shops at various bus station in Karimnagar region, my lords. Will the respondent herein will submit a tender for establishment of a plastic and leather goods shop, and he became the highest bidder, Milord. He offered rupees 6,254 per month as a license fee, Milord. Accordingly, an agreement was entered between the parties, Milord, on 14/2/1997 for a period of 3 years. Milord, the respondent, after that, the respondent submit representation on 19/2/1997, requesting the appellant corporation, Milord, to allot open space at at platform number 19, Milord. Milord, the request of the respondent was rejected, Milord, and informed the same to the petitioner, to the respondent here, Milord, 27/1997, Milord. Milord, the respondent herein, who is the petition, Milord, failed to pay the monthly fee, Milord. Therefore, Milord, on 25/6/1997, Milord, we have issued show cause notice, Milord, at page 21, Milord, for terminating the license fee, and we have forfeited the Milord security deposit, Milord. Agreed by the same, Milord, he filed the Milord petition before this honorable court, that is WP number 16438 of 1997, Milord. Milord, during the pendency of the petition, Milord, we have terminated the Milord his license on 15/7/1997, Milord. Milord, during the pendency of the petition, Milord, the learned single judge directed the Milord, the respondent to make a representation for refund of the Milord security deposit. But that was also, Milord, rejected by the Milord corporation. Milord, the learned single judge, Milord, partly allowed the Milord the petition filed by the Milord respondent hearing. Milord, your action, kindly see the Milord operative question, Milord, at page number 10, Milord. Permit to read, Milord. Page number 2, operative. Now, the learned single directed the Milord corporation to refund the Milord EMD amount at the rate of 9% per annum, Milord, by deducting the 2 months license period, Milord. Agreed by the student, we have filed writ appeal before this honorable court, Milord. Initially, this honorable court, Milord, has Milord granted stay, Milord. My ambition before your lordship is that in the tender notification, there is no specifically mentioned that the Milord with regard to the open space platform number 19, Milord. Milad, the petitioner who is the respondent hearing Milad is seeking Milad for allotment of his Milad shop at specifically at platform number 19 Milad. That Milad we have rejected Milad.
Where is the agreement?
Milad that agreement is not fair, but we have extracted the Milad class 30 and 7 of the license agreement in the showcase notice Milad, page number 22 Milad. Paragraph 2 Milad. Page 22 paragraph 2 Milad. As per the report received from the married. As per the report received from the depot manager Karimnagar, you have not paid monthly license fee from March 1997 onwards. Further, you have not installed the stall till date and not commenced business. Thus, you have violated the class 30 of the agreement executed by you. Class 30 Milad. The license is liable for termination in the event of the licensee failing to do, liable for termination in the event of the licensee failing to do business for which the license is granted for a continuous period of 90 days, which shall also carry necessary penalties and forfeiture of security deposit. Now, Milad, in the instant case, Milad, the respondent did not commence the Milad his business, saying that he wants to a specific allotment for his shop at Milad platform number 19 Milad. Further, as per the terms and conditions of agreement made class number 7, the licensee fee is increased 6,254.
No, I read it. In addition to this, changes that this action has been taken in accordance with clause 30 of the agreement. That's dictated. Clause 30 here, page 22. If you fail to carry on money despite allotment, did not carry on business and requested for platform number 19. Therefore, they have in addition, we have variables without cancellation of the agreement. Huh? Yes, madam.
Anything else? Who appears?
What you have to say? Action has been taken in consonance with the clause 30. What is wrong?
Dear Milord, I have submitted my tender. Seeking allotment of space on platform on 19. Tender notification is silent about the location of the stall. My tender was accepted, Milord, by the corporation. And allotment order was given. And in the next thing also, Milord, the location of the shop was not mentioned. They are not including the less state. They asked him to finish the state. And interpreted location of the star.
That means you did not hear us. What did we say? Action has been taken in accordance with clause 30. After allotment of this thing shop to you, you did not commence the business within a period of 90 days. You said that I want platform number 19. That was not the NIT.
That's what the learned said. Not there is part of the recovery arrangement. That's right. 2006. This is part of the now what that the order of the learned that legally sustainable.
Not sustainable.
that is observation made by some from the.
We don't know. The observation is legally unsustainable, therefore stay has been granted.
Legal section. Legal section, but the order. Six, then they have seen.
Legally unsustainable, Mr. 10th July 2006, you see this. 1 minute. Just don't say anything. Yes.
Now, that talks to the bar and reading that. Now, you can get, you will be that period, because of the point of this point. The legal section. Because on the cap, less the report was not carried. There are further the two, that if the amount of people funded to respond. The upgrade.
No. So, in your opinion, the opinion of division benches, it is legally sustainable. Therefore, writ appeal should be dismissed. This is what it is written, Mr. You don't read it. We don't know which copy you have got. Our copy, it is clearly written. No, we have the original order. You read last paragraph, give it to him. Last paragraph of the order.
Second paragraph.
No, last paragraph of the order. Hey, Mr. Read last paragraph of the order. Read last paragraph. Read it aloud, we have not read.
There is even a refund of the point. But in the sum of 1,500.
Answer, read. Why have you stopped? We are not concerned with that copy. Legally unsustainable. Right, it is there in our copy. That is not the ground, but you are insisting sustainable this thing. No, nothing turns upon the decision of this writ appeal does not turn upon what copy is supplied to you. It is dependent on a legal issue arising in this case. So you argue your own case, Mr. That instead of supplying, we will conduct an inquiry about how have you supplied, who has obtained this copy. No, we are not concerned. Nothing turns upon the interim order.
Here, by example, the report display tender road not tenders for open for running that rather to start without matching location of the star. But the petitioner has subject tender seeking allotment of space on platform 19 of the tender. My tender was accepted. They accepted the location from the job where I was. Then they asked the order. The allotment order also did not specify the location start. Thereafter, immediate electricity. The electricity also did not mention the location of start. Suppose the tender notification is silent about location of stars, but if it is the tender, it was in corporation that needed to open the column platform 90. Suppose they feel that the tender submitted by the minister, not with the tender notification, he mentioned, so place I want. Then it was rejected. The corporate was rejected by tender, but not be accepted by tender, allowed to given to me. Thereafter, I have very significant point on the advance license. Thereafter, the corporation, the regional bank, included license. The licensing also, the responding, the application, the responding is not specify the location star where the have coming. Thereafter, Immediately after completion of that, the after the after the response to produce let's see, they have produced before the after then it will some work that is now open is from other than where I have then I write my application. Now the place which is not mentioned in that not wanted by me. That can look at that did not in place where I wanted. I did not satisfy the job. I have deposited advance input involvement on advance. Then I will for the things not in place where I wanted. My representation was then I was instead go down now when comments were in then I have some my aspects by our legal book. At the stage I want taking because the outlet regulated election. There I'm from after hearing the learned judge directed the responded the he made a representation refer to the government to refer to the people before. Then also about the order. This is what I made a representation equal to the refer by people before. My representation was the
1 minute. Where is the tender, Mr.?
Page number 24, Millard.
24.
Sorry.
See 24 tender.
24 Millard. I'm sorry, I didn't tell you.
Where does it say that particular place?
There is no mention with regard to particular place in tender notification. Page number 24 Millard.
Then
we're not mentioned it specifically at platform. We stated that.
Then he said that you give me platform number 19.
Then Millard, we stated that there is no mention with regard to the specific place in the tender notification. Therefore, we rejected the representation. Millard. In the tender notification, we stated that.
Mention of the particular place. I said maybe in platform 19 rejected and forfeited. So when he said that you permit me to have it on platform number 19, what did you do?
Millard, we rejected Millard is requested.
Rejected, and when did you reject?
Millard, we have rejected on Millard 27 to 1997.
And when was this forfeited?
Millard, that was Millard, we issued show cause notice Millard on 25/6/1997.
So why you rejected this thing when no place was mentioned and he said that permit me in platform number 19? Why did you reject it?
They rejected on the ground that Millard in the tender notification we have not mentioned with regard to the platform. We have stated only open space Millard the tender notification.
Also open space, he said that you provide me in platform 19. Why did you reject it?
But that was because my humble submission that was not there in the Millard tender notification. Therefore, we rejected Millard his application. Millard.
See, please see in the representation, I have also given a legal notice which you have not responded. Have they given any legal notice?
Nothing.
And even in the allotment letter, have you specified the area what he wanted?
In the allotment letter, in the lesson, we are not specified area. Because in the tender itself, your Ashok can see very clear that open space at 5 into 8 for plastic and leather goods. Now, Millard his contention is that he wants to run the Millard establish.
How are the other stall owners? How you have given to them earlier the others? There might be some existing stall owners, right? What was the modus operandi in giving them?
Millard, for others, Millard, as per the Millard, they are not raising this issue, Millard. Only
no, you please answer that. It's an open tender, right?
Yes, ma'am.
So, on what basis you were giving? Based on their preference or based on availability?
Based on the Millard availability.
Okay, have you informed that this place is available and here only you have to install it? Any such communication? All right.
Then nothing, I mean, it's not Keshwanand Bharti review, right? It's a wall. Yes, all right. Yes, madam, right. This intra-court appeal arises.
Please, no?
How you did. Six cases.
This, the appeal, challenged by the forest department, the challenging the only, the brief facts, may I narrate the three dates. The petition filed by the NTPC, the challenging the impugned order issued in the 1986, the claiming some amounts for violation of the Forest Act. That was challenged. The learned single judge, while dismissing the writ petition, the imposed the cost on the respondents. That is under challenge for my knowledge. Imposing 1 lakh, the impugned order at page number 15, page number 15 onwards, the relevant portion.
You are NTPC.
I'm the forest department appellant before my
Writ petition has been dismissed.
This writ petition is dismissed. Challenge the imposing the cost on the respondent forest department for the improperly issuing the demand notice. That is under challenge before my lords.
May I mention, Your Lordship, writ appeal number 927 of 2010 was filed by NTPC, Your Lordship. And my learned friend filed the 708 of 2010, the writ appeal on the same judgment, Your Lordship. Actually, Your Lordship, this is a case, Your Lordship, so far as the NTPC is concerned, it needed I made a summary, Your Lordship. To construct the ash pond, Your Lordship, it was in need of 1500 acres of land. And the state government has sanctioned that land. And the land which was sanctioned was somewhere in 31/12/79 and 3/4/1980. And it came under AP Forest Act of 1967, Your Lordship. Then we paid the entire compensation amount as well as the compensatory amounts as well as 25% of the tax amount.
1 minute. You have given us this latest, permit us to go through. You have written everything, but you have not written what is the impugned order.
You not read page number 18.
Page number
That
I'm sorry.
we have to read. No, that's.
But they, I'm
Page number 47.
We thought that synopsis should be complete in itself. Nothing.
Item number 8, your lordship, page 47, 49 is the impugned order.
With this only. Where is that?
Item 708.
Impugned order.
35 item.
Page
708 of 2006.
705/4/2006. What is the impugned order? The suspense is still continuing. What is the order?
40. Your lordship can see 28 to 40. Last paragraph, I have written the judgment.
No. Order impugned in the writ petition. Where is the writ petition copy?
Judgment.
But the impugned order.
There is no writ petition, right?
In my material papers, page number 9 is the impugned order.
There has to be writ.
In my papers, it is page number 9.
Writ petition papers. Material papers filed by a separate book, 1 to 172.
9 to 26.
This is WS. They are unable to tell us what is the impugned order. We have to read.
I take my lords only one
No,
minute.
thank you. Thank you. Thank you for your assistance.
Page number 18.
No. This is WP. Madam, this is WP. You give it, the whole thing, give it to them. Let them point out where is the impugned order in the petition. Give it to them. Put a flag and give it back.
Otherwise, I have questions.
No, it's not on record, right?
In my material papers, it is page 9, your lordship. Page 9 to 26 is the.
Give it to madam. Let them find out.
Lord permits me only 1 minute.
We will, why 1 minute? We will permit you for 1 hour 50 minutes. But who will write the order? We have to write the order. Therefore, we must understand. You are not even telling us what is the impugned order. She has given synopsis where impugned order is not. You see what it has written.
I extracted that portion, your lordship.
Where is this, mister? You don't understand. You also don't know.
Page number 18, Lord. Notwithstanding the repeated directions of the Honorable Supreme Court.
Counsel, please show the impugned order which you filed in the writ petition.
Order impugned in the writ petition 5/4/2016. You are telling us something else without seeing it. This is serious thing, mister. Abdication, like.
This was filed in 2000.
No, final hearing matters you are not prepared. Then the court is asking what is the order impugned in the writ petition before Learned Singanjat. You are putting flag in somewhere else and getting away. Unfortunate.
I sleep only 1 week time, Lord. 3 days, Lord.
Why?
Till I will compare.
No, 2005-6 matter.
Not all the bundles are not properly made available. Even records also, my records also. And my office also.
It is most like this thing. We should send the copy of the order that after 17 years your counsel seek adjournment.
Only it's. But the original order copy is there.
No.
My lord's perfect.
No, mister. You are, please sit down. It's our, this thing, we have taken oath to do justice, we will do justice. If it is against her, she will go in SLP because the NTPC has no paucity of funds. It has plenty of money to spend on litigation. So she will go if it is against her because it's our duty. Why should you bother? Sit down. We have taken oath to do justice. We have to assign reasons, passing the order. You can also go to the, you have also plenty of money to spend in litigation. You can go. Yes. Sit down, please.
May I mention, Your Lordship? My friend is eager only with regard to that 1 lakh rupees fine, Your Lordship. Whereas the case is mine, unfortunately, in the numbering, mine was an higher number than the lesser number. That's why he wants to argue the matter, actually. In the impugned order, Your Lordship, for the afforestation of the land, 1:2 ratio along with 15,000 rupees compensation per acre should be given. That is the demand they have made under GOMS number 172, which is at page number 47 and 49, Your Lordship. And 3 prosecution notices were given by the government. So a writ petition was filed and a stay order was granted, Your Lordship. Later on, Your Lordship, the learned judge has given liberty to file a fresh writ petition. Consequently, WP number 12512 of 1992 was filed, challenging the order, the authority of the Forest Department to issue the issue such orders.
Order impugned in the petition.
Now, Your Lordship.
Impugned order. We want to understand what is challenge. Which other WA? There are 2 WAs. Yes. Other WA matter. They are formal parties. He has nothing to argue. The government advocate.
Yeah, the appellant.
1 minute. Your fate of the will depend on what type of order we passed in this in her appeal. She is NTPC. You are not NTPC. So whose appeal should be heard first?
I was requesting that only, Your Lordship.
You are standing like and creating confusion, seeking time. Sit down, mister. Your fate of your appeal will depend on her. In the meanwhile, study, got an opportunity. Go through the file if you have not read it.
No, if
What is the order under challenge in the writ petition?
the order is at this learned single judge order is at page 9 in my material paper.
Not learned single judge, madam. What is the order you have challenged before learned single judge? He has written an essay in the order without referring to what is the challenge.
GOMS number 172 dated
which page,
1988.
47.
Page 47 to 49, Your Lordship.
47.
GOMS 172.
172.
No, not 20. See, she has
Page
said
number
that
47 dated 25/5/1988.
no. This is the written order of the learned judge. What is the order challenged by her in the petition?
Because first I have challenged it with regard to 1:2 ratio a letter, Your Lordship. Later on, I filed an amendment application challenging this GO, saying that the government is not empowered to ask for 1:2 ratio as well as the 15,000 rupees per acre.
Where is your writ affidavit?
At page 28 to 40, Your Lordship, first writ petition.
In the prayer, they are not challenged any order.
Page 40 of the second writ petition is the prayer. Page 40 of the prayer. Yes. Okay.
Para 18, Your Lordship. Under these circumstances, it is just and necessary that the Honorable Court may please to issue an order or direction, particularly one in the nature of writ of mandamus, restraining the respondents from claiming compensatory.
Where is the order claiming this thing, compensatory afforestation? That is the question.
That order
In the prayer clause also you have not mentioned it, as vague as possible, right?
Your Lordship, that is a mistake occurred, so I filed an amendment application, Your Lordship. That is at page number 151 and 158, Your Lordship. And this petition was kept pending and the main writ petition was heard, Your Lordship. Otherwise, normally amendment has to be allowed and that to be carried on. This confusion arose because of that, Your Lordship. Page 156 to 158 is the, with regard to challenging GOMS number 172, Your Lordship. Your Lordship will get it page number 158. Under the above mentioned circumstances, it is just necessary that this Honorable Court may please to issue an order declaring the conditions imposed in GOMS number 172 dated 25/5/1988 and a consequential order on 29th April or May 1992 issued by the first responder illegal, arbitrary and discriminatory in nature of consequently direct the respondents to approve the occupation of 380 acres of land for non-afforestation as per the provisions of the guidelines under the
Madam, please do not, we are reading it. Please, don't start reading anything like 152, you start reading 152. We are going through your petition. What is the, to find out what is your case pleaded? Please permit us to read it. It's our job, no, as we, that to pass an order is our job. So we are doing, we have to understand what is the petition filed by you. Okay. This order 25,588 is the order understanding. Where is 25,588? 47. 47. All right, we'll continue. You go through, madam, in the lunch. What is the case? Please study.
I studied it, your lordship. But the way method and manner of telling is different from thing, your lordship. That is the latest GO on this act, your lordship.
as third gender. We direct the center and the state governments to take steps to treat them as socially and educationally backward classes of citizens and extend all kinds of reservations in cases of admission in educational institutions and for public appointments. Center and state governments are directed to operate HIV surveillance. This, Your Lordship may skip.
Only three, Lordship. Only three is important.
And 9. Well, last year, they treated her as a female. She lost a seat. She made a representation to them. From the date of her representation, which is on 1st February 2023, to both the state government, the central government, and all the other authorities, till today, there's been no response from any one of the authorities except the university. And the university's response is, we are governed by the central government and the state government, not by the Supreme Court. They don't say the later, but they say the former.
So what does this thing? Number 3, 129.3.
We direct the governments to take steps to treat them as socially and educationally backward of citizens and extend all kinds of reservations in cases of admission in educational institutions and for public appointments. So they are required to provide a reservation in SC/ST. Your Lordships, in the other case, Your Lordships may recall, this Honorable Court said, you will treat them as scheduled caste, scheduled tribe if they belong to that community, and treat them as this and give them which among the two is more preferable and preferential to them. In my case, they treat her as a female.
So you belong to which category? No, this thing is.
I have
neither
ST.
ST. All right. So we will have to give them some this thing. Yes, Mr.
My submission, Lordship, says me,
like earlier, there is one order which is already passed, no, by the erstwhile division
Lordship,
bench.
kindly say, my friend says, Lord, she is to be treated as a third gender. Rules of admission do not provide such a reservation. But she cannot have a separate. This government, direction was given to the government of India and state.
That we will have to adjudicate, right? I mean, today itself we can't direct that provide reservation, ensure compliance in 2 hours, and this can't be done, right? So they have to be given time. These directions are binding on union and central government. So central government and your state government, so they are binding.
As per the merit.
So what happens tomorrow?
As per the merit, Lord, she rank is not 1,55,000 and odd.
So that's why they are here.
There is no possibility.
Otherwise, if you would have been a meritorious candidate, do you think you would have filed a petition?
Even in ST category, even if she is considered in ST category, the Supreme Court says socially, economically backward classes. But even if it is considered ST.
This is apart from the fact that she is already, if a person falls in more than one category, she is scheduled, as per her claim, she is scheduled tribe. And there is an interim order, by the division bench saying that, where is that order?
Your Lordship, direct.
1 minute.
Page 172 of the present.
172. This thing, 20th July.
Kindly come to page 180 of that, my lords. The order starts at page 172, 20th June 2023 order.
See, 180, Mr.
180, Lordship. In the meanwhile, counseling commences for NEET PG 2023. Respondents are more particular. Respondent number 6, Lordship. Shall extend the benefit of third gender status in addition to petitioner status as a scheduled caste. Here is a
No, we understand your defense stand fully well that it is for the central government and state government to provide for reservation, and there is no provision. We cannot admit on its own. There is no provision for reservation of third gender status. That's all right. But what to do tomorrow? They have also come guilty of coming 11th hour. Always they rush like this.
The university will consider.
This thing similar order. No?
May I only show one thing, my lords? My friend saying that this is only against the government. may not be correct, only come to page 184.
Thereafter we have.
Thereafter, it was also made applicable to the university. After hearing the learned counsels for the parties, the state government as well as respondents 6 and 8 are directed that to extend the benefits of third gender status in addition to her status as so and so while considering.
We'll consider on the basis of merit, on the basis of ST category merit, we'll consider it. Even in the earlier case also, where the taking into account in obedience with order passed by Honorable Court, that she was given admission. For that they filed.
There is a dispute, right? He also wants dermatology. Everybody wants dermatology.
He didn't want
medicine. Whatever. Like it's a preferred this thing. See, this benefit of third gender status means seat according to my choice. That's it.
Very difficult. Very difficult.
Not difficult it is, but what to? There is an order. Is according to him seat of my choice. If you give, then only you will give me the benefit. That's the argument in previous case. You have admitted her in MD medicine, but whatever medicine, emergency medicine, but that's the argument that it is not this thing. So what happens to this interim order, Mr.?
We'll consider.
We'll pass the same order.
On the basis of the merit case.
They're not merit. This is the order at page 180, Mr. Prabhakar. This has been passed. How can we?
But we also filed.
And you know, Supreme Court Siliguri municipality. What does it say? Interim orders consistency have to be. How can we?
Earlier case we filed.
Whatever is the consequence, we don't know.
We filed.
Supposing if you consider her tomorrow and get this thing, a seat, she gets a seat of her choice. She may not contest the petition also. We don't know. We don't know, but this needs to be.
The cost of merit we cannot consider. We'll consider your lord's order.
What to do? There is an interim order in similar circumstances. We'll have to issue notice. We are giving you opportunity to file counter. It's not that. Heard on the question of admission.
Of respondent number 5, my lords, National Medical Council.
Yes. Note. Issue notice. Right. Notice on behalf of everybody. What is that? Accepted by so and so unrepresented. Notice to unrepresented respondents. Petitioner is a candidate who has appeared in the NEET PG examination for the year 2023-24. The petitioner. Full stop. The first two rounds of counseling for admission to NEET PG course have already been held. The grievance of the petitioner, full stop. The grievance of the petitioner is that notwithstanding the judgment of Honorable Supreme Court in Nalsa versus National Legal Nalsa versus Union of India 2014 volume 5 SCC 438, the benefit of third gender status is not being accorded to her. It has been averred in the petition that in addition petitioner is a candidate belonging to scheduled tribe as well. Paragraph. Learned senior counsel for the petitioner has invited the attention of this court to order dated 20th June 2023 passed in WP number 15117/2023 and has submitted that similar interim order be passed in this petition as well. it is submitted that it is pointed out that third round of counseling is scheduled to be held on 4th of October 2023. On the other hand, Mr. Prabhakar Rao, learned counsel for the university, submits that a provision for reservation belonging to a person to third gender category has to be made either by the central government or by the state government. And in the absence of such prescription, university on its own cannot provide a password. Password? Which password? 31? No, no. This we will take. Mr. Vaidyanathan. Yes. So we had gone through this thing records. You are relying on this. Essentially, your submission is one of the submissions is other facts are that it is a dispute arising out of a power purchase agreement between a generating company and distribution company, and therefore it has to be redressed in the manner indicated in power purchase agreement, like firstly by negotiation, then by arbitration, and then like the tribunal can, or that commission, electricity commission. So, but we don't, where is this, the complete PPA providing the clauses, resolution of dispute by
The relevant clauses have been extracted. The complete PP has not been filed.
Not filed, no. Where do we get?
That we can file those.
Give.
The relevant clauses.
Relevant clauses only.
Yes. Kindly have a look at that now.
So we believe that you have heard Mr. Reddy for AP Genco, right? What all he said.
May I give the synopsis, my lord?
You have supplied a copy to them.
Yes. In the morning only.
The relevant clauses have been extracted in the order of the State Regulatory Commission, which is present at page 78. 78.
Of WP 37555.
Of WP 37599.
WP 5. Ah, yes, yes.
Yes.
So, which internal page?
78.
No, no, that we have got in another appeal also.
Yes.
Another writ petition also. Which internal page of the order?
Page 25 of the order.
25.
25 of the order.
Or you can mention paragraph number, then it's better.
Paragraph 78.
78.
Yes.
Arbitration provision.
Yes. And Miller, interestingly, during all this time, in August, Miller, I wanted complete data, but since my lords have asked this question, Miller, I think it's very relevant. Miller, on June 3rd, 2022, rules were made in regard to how these Miller, payment mechanism. Kindly have a look at that. Under the AP Act, under the Electricity Act, internal page 6. Therefore, in addition to any dispute resolution mechanism, in case of any outstanding dues, kindly have a look at that page 6, internal page 6, 1.3, rule 1.3.
Oh, which internal page 6 of what?
Of this gazette notification. Gazette notification. On 3rd June, this notification was issued notifying Electricity Late Payment Surcharge and Related Matters Rules 2022. These rules shall be applicable to outstanding dues of generating companies, interstate transmission licenses, and electricity trading licenses. Act means Electricity Act, etc. And it sets out how all the pending bill, outstanding amounts, how the arrears are to be liquidated. Provision is made, and payment security mechanism and its consequences, therefore uploading the bill, and then over in a period of in various equated monthly installments, when the amount is over 4,000 crores, 40 installments, etc. All these are provided for. This is all. These rules are made by the central government, Ministry of Power. At the same time, when all this is going on, therefore, we have the State Electricity Regulatory Commission, which has to resolve the dispute in case of failure of mediation or discussion, etc., arbitration. Then there is a second mechanism provided by the Government of India in regard to outstanding dues for generating companies. And please see importantly, Rule 2H of that rule, outstanding dues, means the dues of a generating company, electricity trading licensee, or a transmission licensee, not stayed by a competent court or tribunal or dispute resolution agency as designated in the power purchase agreement. Let's hear this particular demand has been stayed by a competent tribunal. It cannot be treated as outstanding dues within the meaning of the Act.
they moved the High Court of Andhra Pradesh by way of a writ petition, not stayed. And the interesting argument advanced is the combined Andhra Pradesh Electricity Regulatory Commission has been dissolved. Therefore, the order is not valid. Extraordinary. The Act provides for two separate regulatory commissions having to be formed to take over. Whatever order is passed will continue to bind. There is no provision which enables dissolution. On dissolution, the order becoming void. No such provision has been pointed out because none exists. They will continue. Otherwise, it will be meaningless. A competent tribunal, competent authority has passed an order. Writ petition is pending. They have not withdrawn it on the basis it has become infructuous. It is still pending. No interim order. That you can't possibly go and then move some other authority because now this mechanism is also cannot be availed of. They can't seek to execute it. They have not gone to a civil court. Well, they filed a writ petition, withdrew it. They went to the company court, NCLT, withdrew it. Now, this is a very extraordinary method that they have invoked. Now, I want to briefly summarize what has been argued. Yes. Yes, that's correct. Well, the submission that has been made by the central government as well as the state of Andhra Pradesh and the AP Genco is that there is an admission in regard to this.
No. 5 occasions you have admitted.
Yes. And therefore, the administrative or statutory administrative order has been issued by exercise of statutory power under Section 92 for directing the state of Telangana to make the payment to state of Andhra Pradesh. My lords has put a specific question. The due is as between the GENCO and the Distribution Commission. How does the state come in? State comes in because all these companies are owned by the respective state governments, either the state of Andhra Pradesh or state of Telangana. These are separate entities, statutorily recognized. And the statute under Section 92 read with the schedule contemplates the PPA continuing. Therefore, whatever is a provision in regard to PPA, in regard to resolution of disputes, will also continue. No answer to that. This is not overridden by a law made by the Parliament in exercise of power under Article 3 and 4. No attempt to override the provisions of the Electricity Act, which contemplate the State Commission discharging its functions under Section 86(1)(f) to resolve the disputes. The central government has not dealt with the submission made by me in regard to the state granted by the State Regulatory Commission. I have already pointed out what was the submission of the AP Genco. Interestingly, when the submission is made that there is an admission bias, reference is made to 3 documents. One is the meeting which has taken place in 2019, which is on page 170 of the writ petition 37599. There are 3 documents. I shall place all 3 of them. This is referred to in the draft letter, although the final letter
37599 W3. Must be.
The draft communication, which is in the noting file, refers to this at page 47. To a meeting which has taken place on 19/8/2019. It starts at page 170. And representatives of Andhra Pradesh and Telangana are there. Now, please see, this document talks of power bills, both agree. Andhra Pradesh, amount due by Andhra Pradesh is 8,199, amount due by Telangana 11,641. Then interest agreed to pay net amount. Now, please see various other things that are mentioned also. Amount payable and netted amount 12,648 due and 10,160 by Andhra Pradesh as on that date, but further amounts to become due once the bifurcation takes place. Bifurcation has taken place in regard to employees. Those amounts have become due, like for example, item 3, demerger adjustment and employee bifurcation 1,180 crores, all these have taken place. Therefore, no reference is made to this, and I shall place the judgments of the Supreme Court there. An admission is found in a document subject to certain netting off. Both will have to be taken into account. You can't pick out one. That's an extraordinary argument. You pick out one. This is one document that they refer to. Now, the second document that they refer to, please have a look at the noting file, page 12. Please see, noting file,
page.
There are two pages. One is page 13 first, page 12 first. Page 12. And reference is made to the meeting of 8/11/2021. The learned solicitor had referred to this and said, para 3, in order to resolve the matter, Secretary Power chaired a meeting with the representatives of Government of Andhra Pradesh and Government of Telangana on 8/11. As recorded in the said meeting, following facts emerged. There is no dispute of the principal amount to be paid for power supplied by Andhra Pradesh to Telangana. However, some reconciliation is required on the interest to be paid on the principal amount by AP and Telangana. Both states agreed to reconcile the figure as per the term. Now, please see, this so much was read. Paragraph 3, opening paragraph, and subpara A was read by the learned solicitor. What was not read was subpara C. Telangana has claimed certain amounts to be paid by Andhra Pradesh on account of issues related to the outcome of the demerger of the three power utilities affected by bifurcation. Telangana representatives committed to pay the net amount, if any, after incorporating demerger related dues and the remaining dues for power supplied by AP Gen. Now, an admission, you can't read one paragraph and say, I have admitted, when I have said that it is subject to adjustment and setting off of these amounts. No, this was not even referred to or dealt with. And therefore, please see the last sentence in the subpara C. However, both Andhra Pradesh and Telangana have not received the orders as per recommendation so far. Therefore, fault is in regard to both. Now, kindly come to another note at page 28. This is of 8 July 2022. para 12 and 12.1. As on date, the claim made by Andhra Pradesh is unsettled for non-payment of dues to the extent of around 6,000 crore by Telangana Discom after bifurcation for electricity. Subsequently, Telangana, by the letter dated 5/6/22, has claimed that Telangana has received an amount of 17,420 crore and owes an amount of around 4,887 crore to Andhra Pradesh. Thus, the net amount receivable from Andhra Pradesh would be around 12,500 crore. However, it is felt that these amounts are not supported by any document and may not be taken into cognizance. This is extraordinary. How do you say that we have produced all the documents and will some section officer records that these may not be taken into account? Surely, Miller. And they are not adjudicating, they are not rejecting this claim. These still remain. Now, please see all these, the way it has been dealt with. Let's kindly now come to page 143, the other letter which was referred to by both the solicitor and the counsel for senior counsel for Genco Miller, AP Genco, page 142, letter addressed by Mr. Harish Rao to Mr. The Secretary, Home Secretary, and same letter is addressed to the Secretary Power also. 142 is the letter to Home Secretary, and page 148 is the letter to the Secretary Power. And Miller, reference was made to one item, receivable, total receivable from AP Genco, etc. All these are referred to. Miller, payable to AP Genco, last item in there, for power purchased by Telangana State Power Corporation. This amount is referred to. This is a statement in regard to amount receivable from AP Discom. You can't pick out one item and say there is an admission by the Minister for Finance of the government of Telangana, therefore on that admission I pick. But admission is subject to all these. And Miller, in the letter, he says there is net receivable by Telangana Power Utilities is 12,532 crore on basis of justification. And the prayer is therefore consider all these together. None of this is considered. Now, Miller, please see, now the reference was made to minutes of meetings. Minutes of meetings, please see the very minutes that are referred to by my learned friend, Mr. Mohan Reddy, two pages, page 98 of the counter of the subcommittee meeting. In the counter affidavit, they have annexed 2 minutes.
Dated, which date?
Page 96 of the counter is the letter enclosing the copy of the minutes of dispute resolution subcommittee. And the letter from Government of India starts at page 95.
Counter. Page 95.
95 is the letter, covering letter. And Miller, page 97 is the summary of discussion. Payment of power dues by AP Genco to Telangana Discom. And kindly now come to bottom of the page, use of
This is 17th February 22.
Sorry. 17th February.
All right. Yes.
Yes. Now let me see views of the Ministry of Power. Representatives also inform that has been referred to law. Can the order be given for payment, etc. Kindly now come to conclusion at page 98. Joint Secretary CS suggested that after getting the dues of Ministry of Law, Ministry of Power may communicate the same to both the state government and the Ministry of Home Affairs for the comment further action will be taken on the issue based on the comments of both the state governments and the opinion of Ministry of Power thereon. Not communicated. This is the decision of the Ministry of Home. Who is chairing, the representative of the Ministry of Home, kindly come to page 102 participants. Ashish Kumar, Joint Secretary CL from the Government of India. He is heading, and whether the Department, Ministry of Power, one Mr. A.K. Garg, the Deputy Secretary attend. And this is the decision taken that they will communicate the same to both governments and Ministry of Home Affairs, and action will be taken on the issue based on the comments of both the state government and opinion of the Ministry of Home. So action will be taken, please see Ministry of Power, Ministry of Law and state governments of AP and Telangana. Kindly now come to the next minutes which was referred to, page 113. Actually, the meeting notice is at page 104. A meeting notice. Then the minutes are here. It starts at page 113. Second meeting of the resolution subcommittee. And will it kindly come to views of Ministry of Power. Please see page 114. Decision. Ministry of Home Affairs will be taking up with the Ministry of Power and Ministry of Law for the comment to decide further course of.
You are referring to meeting of which this thing?
Of the dispute resolution subcommittee, which my learned friend had referred to. Page 113. 17 June 22.
17. It's page 117 in our copy.
Oh, I'm sorry, Millet.
117.
Millet, counter affidavit minutes. Page 113 of the counter affidavit of AP Genco, Orphic.
Counter affidavit of respond number 5, right?
Yes, that's right.
Yes. 117. All right. Minutes of meeting.
Yes.
Yes.
Yes, sir. Kindly see Millet, internal page, paragraph 4. Payment of power dues, 4.1a.
Yes.
And the decision is in the next page. MHA will be taking up the matter with the Ministry of Power and the Ministry of Law for the comments to decide further course of action. Nothing. Now, please see, when this is going on, what the Ministry of Home had done, I have already referred to the two meetings of the Southern Zonal Committee. Kindly have a look at that. What was happening? They had communicated to us that all these matters will now be discussed again in the next committee meeting, and those are, please see, on the relevant page. At page 164, I have referred to the earlier minutes, Millet. This is the notice. The earlier minutes at page 150, this is the writ petition, my writ petition. Page 158, 28th May 22, 12th Standing Committee of Southern Zonal Council.
Yes.
Which says we will discuss it in the 30th meeting of August. Yes. And meeting notice is on at page 164, August 4. I would like to mention that the retained issues from 12th meeting of Standing Committee on 28th 5 would be included in the agenda for forthcoming meeting, and the agenda, kindly see page 166. Noting agenda item is 165 pending items. And
that we get it. 129th meeting, it was referred for
130th meeting.
30th meeting.
Yes.
We held in August 20.
That's right. And please see what is important there is This is the notice issued on 4th August, which communicates the decision, the standing committee, of a decision taken in May, page 167, third paragraph. Standing committee treated the item as pending with the advice that AP will share the letter with the Ministry of Power and also Telangana's views to be heard at the time when the government of India gives direction in this matter. That's very important. And it is nobody's case.
Page 167.
That's right. 167, third paragraph. And this is the decision of May, and the notice annexed to the notice of 4th August, which is at page 164, saying that Telangana will be heard before Government of India gives a direction. But I have already drawn my lord's attention to where the Minister, Home Minister, the Home Ministry Secretary said that opinion from the Ministry of Law will be sent to Telangana to ascertain their views, not sent. This meeting also, no, we were never heard, and decision taken before the meeting of 3rd September. 3rd September, this was to be taken in the 130th meeting, 30th meeting, not 130th, 30th meeting. 30th meeting. Before 3rd September, the impugned order was. Though the matter was to be taken up in the meeting of 3rd September, order is issued on 29th August 2022. I respectfully submit the whole thing has been done in a very hasty manner, without hearing us, contrary to the assurances held out that we will be heard, contrary to the assurance that we will be told of the opinion from the Ministry of Law. And I respectfully submit that there is complete violation of natural justice, and the only meeting where Telangana is supposed to have agreed is of 2021, and 2022 no such meeting, and in my respectful submission, therefore, there is complete failure to adhere to principles of natural justice, legitimate expectation, equal treatment of the states. But interestingly, in the submission,
with regard to admission, you want to say that it's not clear and unambiguous.
I'm giving the note on that. Just a minute. Before that, I just want to refer to the written synopsis which has been given by my learned friend. And I want to refer to one particular paragraph where some judgments have been referred to. Kindly see page 13.
Just now he is given.
Of the submission which has been given today. Written synopsis.
Yes.
Page 13 minutes.
Page 13.
The paragraph starting, second paragraph. A plain reading of section 9 of the Act shows that the orders passed thereunder are not adjudicatory in nature. As such, the same cannot be termed to be a judicial order. A strict interpretation of the said provision would only drive to one inescapable conclusion, that the central government is bound to balance the interests of both the states in respect of the aspects under Schedule 12, and in this regard, any order, direction, etc. passed under the section shall be construed to be stand. I am very grateful to my learned friend. This is the correct interpretation. It has to balance the interests of both the states, and unfortunately, there has been a woeful disregard of this wholesome principle of balancing the interests of both the states. That I am giving, in order to conduct my submission, I have prepared two notes, and I will quickly take my notes only through the overview part of it, not the detailed part of it. Kindly have a look at it. Okay. And second note also I'll hand over. Let me deal with this first note first, and then I'll hand over the second. On the, my lords asked a question in regard to accounting entries and admissions. Kindly have a look at that. Let the submission in a running account, if there are some claims which are entered against which some other claims are published.
Where this?
Page 1, what the last two paragraphs.
Inner running.
Yes. If there are some claims which are entered against which some other claims are subject to counterclaims are made, will any court so and so. And then this is the question, and then I have referred New Bihar Petty Leave. And please come straight away to the second page, case law summary table, instead of taking my notes to all that. Imani Alai. And the relevant paragraph I have extracted in full. If my lords would prefer to see that, kindly go to page 4. Imani Alai, page 4. Instead of annexing the full judgment, I have annexed all the relevant paragraph. 2011-15 SEC, minutes on the question of admission. Assuming that the High Court should have examined whether there was some other admission to the minutes of meeting relied on by the respondent, let us examine whether there was in fact any admission on the basis of which a judgment on admission could have been passed. Minutes of meeting dated 9/12/2000 no doubt starts by noting that as per Himani's record, credit dispo 47 crores also. It also records as per dispo's records as on 31/3/99 amount due by Himani was 61 crores, 61 lakhs. So, and the three directions which are made, amount due will be 47 lakhs. Thereafter, in para 3, 4, and 5, there is a reference to both the parties agreeing to provide particulars, agreeing to hold further discussion, and the respondent agreeing to check its part to find out the correctness of certain. Thereafter, the minutes conclude that the final figures will be arrived at the meeting. When the minutes merely note certain figures and state that the identity on both the parties will verify the same, and says that the final figure will be arrived at the next meeting after discussion, we fail to understand how the same could be termed as admission for the order. If a buyer states on 9/12, that is observed as on 31/3/99 shows the balance of account with the credit supplier, it cannot be treated as an admission that the said amount was due to the supplier on 9/12. In a continuing account, it might be possible between 31/3/99 and 9/12 there might be deficit account or reversal of credits or settlement account. We therefore hold that there was no admission. Admission should be in the para 11, the underlying portion. Admission should be categorical. It should be a conscious and deliberate act of the party making it, showing an intention to be bound by it. Then in Gordon Woodruff, again similarly, settle account, all those are set out. I am not reading my lords to my lords all these judgments. But broadly, when it says Gordon Woodruff, when there are items both on credit and debit side, both will have to be taken into account and not just one part of it. Then let's say similarly, motorbike, Mullah S. Boy, 1915 Privy Council. The underlying portion, fallacy here consists in so treating an admission. It is permissible for a tribunal to accept part, it is rejected. It is not permissible. I'm sorry. No, I'm sorry. It is correct. It is permissible for to accept part and reject rest of any witness's testimony. An admission and pleading cannot be so dissected, and if it is made subject to a condition, it must either be accepted subject to the condition or not accepted at all. Therefore, when I have made it a condition that these must be checked and the amount must be paid, it can't be rejected. Then when Chamalal Mangaldas, counsel for appellant relied on the entry in the books of account, accompanied by the amounts usual amount accrued. But this entry must be read as a whole, and it shows that the amount with the managing entitled to receive by 4,11,000. Therefore, you can't take part of it. Para 48 of New Bihar BD leaves, my lords are familiar with that. A party to an instrument, para 48, the underlying portion. According to it, a party to an instrument or transaction cannot take advantage of one part of a document or transaction and reject the rest. That is to say, no party can accept and reject the same instrument or transaction. Then that is followed in the latest Murugesen case in 2022. One cannot take advantage of one part while rejecting the rest. A person cannot be allowed to have the benefit of instrument by questioning the same. Those judgments, admissions will have to be read as a whole. Now, one more note. Kindly please have a look at this. On exercise of power under section 92. How any executive power will have to be exercised by government in a non-arbitrary fashion. And I'll just, I have, like in the other note, I have similarly underlined in page 3, the relevant part of the judgment. Then it's metaphor. Paragraph 27 of the judgment. Every action of the state or its instrumentalities should not only be fair, legitimate, and above board, but should be without any affection or aversion. It should neither be suggestive or discrimination, nor even apparently give an impression of bias, favoritism, and nepotism. The decision should be made by the application of known principles and rules. And in general, such decision should be predictable and the citizen should know where he is. But if a decision is taken without any principle or without any rule, it is unpredictable, and such decision is antithesis to the decision taken in accordance with the rule of law. So, when they tell me that we are going to consider it in the next meeting on 2nd September, and they will give us an opportunity, they will give us a copy of the dominant opinion, none of this is done, and they take a decision. Well, this is completely arbitrary. You can't pick out one entry and say, therefore I direct. In a sense, the action order of the state or state instrumentality would stand vitiated if it lacks bona fide, as it would only be a case of colorful exercise of power. Rule of law is the foundation of democratic society. And kindly now come to para 39, extract. Anything done in undue haste can also be termed as arbitrary and cannot be condoned in law. And I respectfully submit, this is a clear case, a textbook case of an action taken in haste. And please see para 40 concluding portion. The facts mentioned hereby clearly established that the corporation and government proceed in haste while considering the application of response board, which tantamounts, considering in case, tantamounts to arbitrariness, thus violating of the mandate of Article 14 of the Constitution. And in the next judgment, referring to S.P. Kapoor, paragraph 25, court held that when a thing is done in post-haste manner, mala fide would be presumed, stating, then post-haste manner in which these things have been done suggests that some higher up was interested in. I have not made any averment, but clearly in this case, somebody seems to have been interested in getting this matter for whatever reason. But the way in which it has been done, it doesn't speak. It's also well settled that if any decision is taken by a statutory authority, it's the biggest according to suggestion of a person who has no statutory role to play. Same would be ultra virus. That's well said. Then Noida Entrepreneurs Association again, that para 28, underlying portion, when a thing is done in a post-haste manner, malified is put to proceed. Then 29, the zenith metaplast is extracted. Then para 39. State actions are required to be non-arbitrary and justified on the touchstone of Article 14. Action of the state or its instrumentality must be in conformity with some principle which means the test of reason and error. Functioning of a democratic form of government demands equality and absence of arbitrariness and discrimination. Rightly, that the Council for Part has accepted that it has to be treating both the states equally, and this is a clear case where our views have not been considered. Rule of law prohibits arbitrary action, commands authority concerned to act in accordance with law. Every action of the state or its instrumentality should neither be suggestive of discrimination nor even apparently give an impression of bias, favoritism. If a decision is taken without any principle or without any unpredictable antithesis to the decision taken in accordance with the rule of law, then it goes on. And I don't think I will trouble my lords with Nagpur Improvement Trust or this Reliance Energy, but Reliance Energy is important in respect of two things: legitimate expectation and level playing field. And here, there is no level playing field between AP and Telangana while exercising power under Section 19. PTC, I have already read on the last occasion, but I am not troubling my lords with that. To conclude, my respectful submission is that this order cannot be sustained, it has to be set aside. Parties should be left to at liberty to pursue whatever remedies are open to them under the law in regard to the enforcement of the PPA, any breach thereof, they are entitled to pursue. It is also eminently desirable that the entirety of the matter is resolved by way of some kind of mediation. Both the states should not be fighting each other like this on all the issues. And I respectfully submit, we are now almost 10 years from the date of bifurcation. These should come to an end. And it will be eminently desirable that the matters are resolved between the two states in an amicable manner. Some respectable mediator. And that will be the best course to be adopted instead of both the states fighting various litigation in different, so many forums. I know I'm appearing in other matters where people are set up, NGOs are set up before National Green Tribunal to oppose projects which have been launched by Telangana to reach drinking water. This is not the way one fights these cases. These have to come here. That's my response. I'm very, very grateful to my lords for a very patient hearing.
Thank you. Yes. Mark the presence, Mr. Stapler. Put it like this way.
May I just clarify one aspect? Minutes, my understanding is referring to PPAs minutes. PPAs have not been approved till now. There are no PPAs in place at all. The PPAs were not approved by the time bifurcation took place. Thereafter, minutes, the state of Andhra Pradesh wanted to withdraw. The ERC minute, which was not in existence by the time it passes an order saying that state government's AP state government's attempt to withdraw from the PPAs is illegal. But that order minutes has no relevance at all. That's one aspect I just wanted to clarify, that there are no PPAs in existence at all. for my lord friend to rely on the arbitration clause, etc. And second aspect, the Southern Zonal Council is an informal body, which has absolutely no role to play in the bifurcation issues, except for settlement at a on mutual understanding at the instance of the central government. These are the two aspects I want. Obliged to you.
Yes.
On the PT1 sentence, the commission went into it and said that the PPs are valid. They have challenged it in the application. Today it can't be argued again. Okay.
Yes, but next case. So let it be passed over. We'll call it tomorrow. 35 and 6. $35. The same thing. Huh? No, which case? This is 35708. Same issue, right? We were taking up. Yes. Call 3530. Yes, madam.
My lordships. Actually, we have challenged it with regard to afforestation as well as the compensatory amount, your lordship. After the Leonard judge has heard the whole case, in the Leonard single judge, your lordship will get at page number 7 onwards the judgment, wherein he has dealt with the whether the Act of 1967 Act and 1980 Act are applicable or not, whether the government is empowered to do so. Because the 1967 Forest Act, your lordship, it gives empowerment for the state government to do the afforestation from the revenue records. Whereas in this case, your lordship, the lands given in survey numbers are according to the state government are in the revenue records. And the revenue records lands have been given to the.
We will hear you, madam. Please give us some time. Central forest conservation. Forest conservation act.
486 with it.
You have challenged the order dated 25/5/1988, right?
Yes, Your
Huh? What ground? It is in your favor. Condition the approval has been granted subject to certain conditions.
No, Your Lord.
No. Are you not challenging the order dated 20?
GOMS number 172 dated 25/5/1988.
That's what we said.
That is in the amendment, Your Lordship. The amendment is not allowed because after the writ
We forget about it, madam. Do you want that it should be allowed and matter should be remanded again?
No, my submission is not. My submission is this, Your Lordship.
We are asking you, in substance, you are challenging the order dated 25/5/1988,
Yes, Your
passed by Government of Andhra Pradesh,
Yes.
granting you permission on certain conditions.
Yes.
What ground you are challenging this order?
That was challenged, Your Lordship, on the ground that afforestation. There were only two grounds. One is the state government once handed over the land. The fight is between the state government and the central government because we paid the compensation.
No, what is this thing? What is it you are challenging in the order? That's what we want to.
We said we are not not going to pay you any amount as afforestation acreage or the compensation.
Please see the order. Come to page. This thing. WA 927 of 2010. We have, with great difficulty, we have found out page 47. This is see, the state government alone has the power to notify the reserve forest and denotify the reserve forest.
Yes.
Right? So it has this thing. It has permitted by this order, it has permitted diversion of 152 acres of forest land.
Yes.
For construction of ash pond, and this has been done in pursuance of the order dated 6th and 7th of April 1988 passed by the state central government of India. Where is this order? See, madam, this come to page 48, internal page 2 of the order 25/5/1988. You don't have even the order.
Just one minute. That order is of GOMS number 172 dated 25/5/1988.
You forget about 172, madam.
Yes.
Nothing. We don't decide because it is 172. Therefore, it is struck down. 173 upheld. 174 struck down. What? Repeatedly, you are telling the number.
No.
Do you have the copy of the order?
No, Your Lordship. I don't know if it is here.
Should we say that the council for NTPC has enough money to spend on litigation, but the council does not have
It is
the
not.
copy? Then
Actually, it is not like that. Your Lordship, may kindly permit me to say, so far as the AP state government order is concerned.
Madam, you have read petition.
No,
Please understand.
I was.
Please understand the query. We have read the case because we have to pass an order. You cannot pass an order. You can file SLP only. You can only file SLP if it goes against you. We are asking you, have you seen what is the order dated 25/5/1988 challenged before the learned single judge?
In the main writ petition, it was not challenged, Your Lordship. That's what I am pointing out.
By way of amendment, it has been challenged, madam. By way of amendment, you have challenged it.
Challenged.
Then what difference does it? We are asking you, what is the challenge? What is it? NTPC. No, that's correct, but we are now dealing with the whole issue, right? We want to understand.
At page
we are unable to get.
WAMP 2142, I took some grounds, Your Lordship. Your Lordship, you can see that.
Explain to him. You explain to her. See, this is Government of India 6/7 April 88. See, in the letter 5th has conveyed approval for diversion of land construction so and so, subject to conditions mentioned therein. What are these conditions? And see, subject to following condition. Order of conversion is in their favor. They will be aggrieved by some of the conditions. So she has to tell that I am aggrieved by this condition. I am trying to ask her. She is unable to understand. We deal with her. The institution is dismissed. No, it should there. Therefore, they are in writ appeal. We are trying to understand what is the case. She is unable to tell.
What I have sought for the, what is with 4 amendments I sought at page number 151 to 156, Your Lordship, wherein I have pointed out it is a central government already enforced the Act number 1 of 67, and the Act passed in section 4 of Act of notification issued by the central government notifying a particular area as reserve forest will be published in the Gazette. They have not done anything like that. It was still not completed. That's why what the learned single judge has passed in the order is that so far as the 80 Act is concerned, 80 Act is not applicable at all. So the entire correspondence is null and void, and the already lands have been given in 17 for 1980. As such, 1980 Act is not applicable at all. So consequently, Your Lordship, as it stands, is the state government. And the state government, it is revenue land or reserve land was given. Now, Your Lordship, I would like to bring it to Your Lordship's kind notice, the latest enactment also. In the Act 15 of 2023, they amended that particular portion under section 1A, and I gave the Gazette to Your Lordship.
1 minute. See, the question posed is, to see GOMS 172, that is under challenge?
Pardon?
GOMS 172 dated 25/5/1988 is under challenge?
That was challenged.
Please. Go to reference 5. Go to page 47.
She doesn't have the order. That's the problem.
Yes?
Yes, 47.
Yes, reference 5.
Yes, from the Government of India, Ministry of Environment, Wildlife, New Delhi, April 1988.
Now, this is the letter on which there was a transfer. There was a recommendation to transfer, which is stated at page 48, para 2. How are you aggrieved by this? That is a question. There are certain subject conditions were mentioned.
Yes, Your Lordship, with these conditions, they have given it to us. And in a normal course, if this is coming.
Which of those conditions you are aggrieved?
That's what I am submitting, Your Lordship. So far as these conditions at that point of time were given.
Do you have a copy of this order? Do you have a copy of this order?
Yes, Your Lordship. Page number 49, I'm looking into that, Your Lordship. But in the main order, the other side has not challenged with regard to the validity of the Act. Whereas we have pointed out saying that the Act number 67 is only applicable, not 1980. Because the 80 is not having a retrospective effect at all. That's why the afforestation lands which are already used.
Madam, learned single judge has also held that 80 Act is not applicable.
Yes, Your Honor.
Then why are you filing an appeal? This is the finding in your favor.
My unfortunate situation was the entire findings were given in my favor, but the writ was dismissed.
Oh.
That's how I come before Your Lordship.
So what was under challenge before single judge? If the finding is in your favor, then what is dismissed?
While writing the judgment, Your Lordship, when I read the judgment, Your Lordship, I found the learned judge was little annoyed with the fight between the state and central government, Your Lordship. That's why he said, apart from in such an unnecessary quarrel between the two departments of the state of Andhra Pradesh, one hand, and the government of India on one, should I read it?
We wish that your arguments can be recorded and could be heard by you. It's not making any head or tail Like reading means you have read amendment, then you are reading this single judge. Then what was under challenge in the writ petition?
In the writ petition, this 172 only challenged, Your Lordship.
Madam, what is 172? Number will not matter.
No, that is the
Substance of the order will matter, not number 172.
Conditions given by the central government to comply, 1:1 ratio or I'll read it to you before.
So where is that order passed by the central government? Now you are coming to the point. See, state, you have challenged order dated 25/5/1988 by the government.
Yes, Your Lordship.
Which condition says that you have to pay forestation charges?
In Your Lordship, they asked the National Thermal Power Corp shall pay the forest department the value of tree growth, if any existing therein, and also capitalize the value.
Yes.
One. This actually that was a barren land. There were no trees. They shall.
No, so we can't decide in 226. But it says if any. You go to the. It says if any. You go and tell the state government that there are no trees. That doesn't mean that say it. We cannot record a finding in 226. None of us has gone there to see whether land is revenue land or forest land.
Because the committee was constituted, it has seen, Your Lordship, we have paid more than 13
Which
crores.
condition, madam? There is no this thing.
They shall by other conditions.
Nothing.
No, the fourth also is not there, Your Lordship. They shall by other conditions that may be imposed by the forest department from time to time.
What is the condition? Madam, again we are asking you, what is the condition which you are challenging? Even unable to tell the challenge, what can be done? What the judges should do? Dismiss the petition, what else?
Compensatory apportionment should be raised in twice the non-forest area with mixed species. There should be no plantation in eucalyptus. Additional non-forest area for compensatory apportionment should be identified and afforested. This is the one, Your Lordship.
So what is wrong?
Previous correspondence, Your Lordship, what they have asked is, for 1 acre, you give 2 acres.
How is it illegal, madam? Compensatory, they have permitted you to divert the land, forest land for non-forest purposes, and they have asked you to do compensatory afforestation. What is wrong?
My submission before Your Lordship is this land was identified first as a revenue land of the state government, and I paid the money to the state government. It is between the state government and the center to make the payment.
This order.
They asked me under 1980 Act, and the 1980 Act is not applicable.
This 6th and 7th April 88. She doesn't know anything right how these people engage in the council NTPC. It's continue. No, they need to see this. That should be asked for.
Madam, do you have a copy of this 6/74-88 letter, which has been referred in reference 5? Do you have a copy of that letter?
That letter I do not. I have to.
That is the genesis of the entire GO.
So if you don't challenge that, no relief can be granted to you.
My issue itself is 1988 will not be made applicable to me because I am in the 1979 area. These people unnecessarily brought as though the act is applicable to me, and the correspondence was done, and everybody was doing the correspondence. We brought to the notice of the court.
May I assist?
We must tell you honestly, we have, at least speaking for myself, I am unable to comprehend what is the challenge, what is the prayer. This is the counsel for NTPC assisting the High Court. Really difficult.
In year 1979, my lord, almost 1600 acres of the land was transferred to the NTPC. Lord, under the two GOs, Lord, GO 1926, 30th December 1979, 590 acres is transferred. Another GO number 1340, dated 3rd April 1980, Lord, the 100 acres is transferred to the NTPC. They are in possession of the property. Lord, later on,
when the government, when the forest department interfered, there is no transfer because of the Act 1 of 1980, Forest Conservation Act came into effect with the effect 27th December 1980. After 27th December 1980, any transfer must be with the consent of the Honorable Central Government. Now the NTPC claims that when the GO, by the two GOs, 1979, 1980, April itself, land was transferred. We are not entitled to, it doesn't come under the Act 80. Therefore, the subsequent GO, which is passed in 1988, 25th May 1988, is not applicable to them. That is their, we will not pay the amount. That is their claim. My understanding.
And that was confirmed with the letter.
I find 3 GOs now.
Please don't say it is your understanding. You have to make your submission.
It's in the 708 of.
You are an appellant, right?
No.
Can you say that I understand like this?
No, that,
who will understand?
I cannot repeat
He is not understanding. You are not prepared to understand then. And we are unable to make out what is the petitioner's case. We are going to write in the order that she has not been able to tell what is her case. We are going to write in this thing. So, Mr. Please understand this thing. We want to be, come to page, this order dated 25/5/1988.
Yes.
This order was challenged by way of an amendment, right?
Yes. That is not allowed, not the.
Allowed up, that is, Mr. Do you think that after 2005, we should remand the matter to single bench? We are dealing with the controversy at large as if it is allowed.
Yes.
When a petition is decided, all interlocutory application and amendment deemed to have been allowed. This is the order under challenge 25/5/1988. You have the copy of the order? No.
Yes. Order copy, I have the copy.
25/5/1988.
Yes.
This has been challenged, right? This is based on, see the first, first page, 25/5/1988.
Yes.
First have it. You have the order. Don't have. Don't say yes, yes.
I have.
If you then open the page. We are going to ask you something.
47.
We'll have to appoint someone as a witness.
You 172.
Nobody is there.
47.
Yeah. See note number 5.
Yes, ma'am. Central government sanctioned the.
No. Note number 5, first page, from the Government of India.
From the Government of India. Ministry of Environment and Forest Department, Environment, Forest, Wildlife, New Delhi. Letter number.
Right. 6/7 April 88.
Yes.
Now come to next page, bottom. In the 5th letter read above, in the letter 5th read above. Read. Read, mister.
In their letter 5th read above, the Government of India have since conveyed their approval for the diversion of the 152 acres of the forest land in Karimnagar district for construction of the ash pond and ash pipeline for Ramagundam Super Thermal Power Project under Section 2 of the Forest Conservation Act 1980, subject to the conditions mentioned here.
So what are those conditions therein? They are not challenging the order dated 6/7 April 1988. Understand, mister?
Yes.
If the conditions imposed by you are in consonance with the conditions dated 6th of April 1988,
yes,
the reasoning is simple. No relief can be granted to the petitioner because they have not challenged the order 6th or 7th April 88. Where is the order 6th or 7th April 1988?
Order copy.
Because you have passed an order in pursuance of this 6/7 April. Got it?
In pursuance of this order only, Lord, the GO, Lord, the 172 came into
the conditions mentioned therein. Now, under which provision, while you have to grant this thing, you have to grant permission for diversion, and when under which provision you can direct that they should this you can impose condition number 7. Tell us. That's the end of it. Consequentially, that's why we are. She has not challenged NTPC. Also, what is Mr. Where is the order of the 6th or 7th April 1988?
That order, Lord, the copy is not filed. Copy is not filed, but it is referred in the GO. Because it's the central government who gives the permission, consent on moving the application by the state government.
Mr. On which basis you have, under which provision you have this thing directed compensatory afforestation? Under which provision you have permitted diversion of land, and which provision you have charging this?
Section 2 of the Conservation Act,
it says that you can levy forestation charges.
that we cannot do. The central government
You are demanding, Mr. You are this thing.
and the state.
Also,
Central government.
hey, Mr. You also don't understand anything, right? Page 47 is your order.
GO.
I know he is central government. He is sitting, but you are. It is your order.
Yes.
Government of Andhra Pradesh. How have you demanded it? That's what we are asking. Which provision?
Section 2, Section 2.
Where is the pro? Tell us. Section 2 forest. You did not make use of this thing, no lunch hour. Wild away time.
And with all the bundles.
What kind of books?
Old matters. We complete these bundles not. After
And this also old matters. We are also handicapped. See the type of assistance we are getting. So which Forest Conservation Act, madam? There is no question. At least you could have taken out Forest Conservation Act. Forest Conservation Act 1980.
Permitted to read, Miller. Permitted to read.
Mr. Forest Conservation Act does not provide for levy of this afforestation. What are you reading? You have not read it ever. First occasion in your life.
Because of guidelines.
Madam, please.
It is because.
Please, madam. Don't. When we ask you to argue, you don't know anything about the case. And then we are putting a query to him and you interrupt. Don't, madam.
Statutory rules made in 2022 not following the earlier rules. Rule 2, the definition rule, compulsory levies includes all monies.
Where is that?
That the rules says.
Which rule?
Conservation Act rules.
22 rule?
That the earlier 81 rules are there, not recently amended.
No, which rule, Mr.? Who has made it?
Constitution rules not framed by the government of.
This is 2022, Mr. And your demand is of 1988.
Last may I kindly see the counter minute filed by the first respondent. Where minute says
which counter you have filed?
Yes, counter.
There 1981 rules are there, provides the opportunity or the details of afforestation compensation. Rules 1981 prepared
Which under which rule? Under which rule?
Rule 6.
Under which provision the rules have been framed?
In exercise of the section 4 of the Forest Conservation Act 1980.
What are the rules?
Sir, called the Forest Conservation Rules 1981. Superseded 2020.
Forest conservation rules?
Forest Conservation Rules 1981. Initially, Rule 7/6 does not provide use the power below.
What power?
Details of compensate afforestation scheme. This provided wherever the land is taken for the
Who can read, Miss? Conveniently, you are not reading.
details of non-forest area, degraded forest area identified for the compensatory afforestation. Its distance from the adjoining forest members, pictures, sizes, and e-map. Map showing the non-forest degraded forest identified for compensatory afforestation and adjoining forest bounds. Details of compensatory afforestation schemes, including the species to be planted, implementing agents, time schedule, cost structure, total financial outlays from compensatory afforestation scheme. Certificate from
Sir, you prepare a note tomorrow. We will continue tomorrow. This thing. Don't like. This is not the way of assisting the court, right? See what type of arguments are made on behalf of petitioner. You have seen how to decide.
That letter.
Madam, you don't.
I'm sorry, Your Lordship. That letter is
Don't
not.
prepare the case.
Nowhere it was mentioned, Your Lordship. That's why I could not get that letter. That is a reference made with regard to that order.
Madam, you know very well that you are not prepared. This is not the way to address a division bench of the court. So it will continue tomorrow. List for further hearing tomorrow.